Can you just read the whole paragraph so that, yes.
In every such case, the suspect must be interviewed and this statement must be completed. This statement must be completed every time the suspect is interviewed, irrespective of whether the suspect is arrested or not.
Zonke isikhathi umsolo uma kufanele ukhulume naye kufanele lesi statement sigcwaliswe. Le statement ke kufanele ukuthi sifanele sigcwaliswe ngazo zonke izikhathi lapho ke umsolo ukukhulunywa naye. Kungabhekiwe ukuthi umsolo useboshiwe noma akakaboshwa.
Paragraph B.
Paragraph ya boraro.
Paragraph B.
B.
Yes.
The member who conducts the interview with the suspect is to complete the statement fully in the presence of the suspect.
Kuthiwa ke ozobe khuluma ke nomsolwa kufanele agcwalise ngokuphelele istatement lesi phambi kukamsolwa.
Okay. Paragraph C.
Paragraph C.
If there is not enough space on any of the pages, the member must continue on a separate follow page. This follow must be signed by a member, suspect, interpreter, and the commission of oath, and must be attached to the statement.
So lana ke uma ingekho indawo eyanele ekhasini iphasa kufanele liqhubeke libhale kwelinye ikhasi leli khasi ke lifanele lisayindwe futhi ilona liphoyisa umsolwa uToliki futhi ke kube ne commissioner of oaths and futhi lifanele linamathiselwe ku statement.
Paragraph D.
Paragraph D.
The commissioner of oath must sign on every page of the statement.
Kuthiwa ke ucommissioner of oaths kufanele asayine wonke amakhasi statement.
Yes. Paragraph.
The commissioner of oath must sign on every page of the statement. If the suspect is a child below the age of 18, the parent, guardian, an appropriate adult must sign every page of the statement.
Uma kuwukuthi ke umsolwa useyingane engaphansi kweminyaka e18 umzali noma omgcinayo noma ke umuntu omdala okhona ufanele asayine wonke amakhasi estatement.
As a good please, my lord, sorry to interrupt my learned friend. The state objects against this line of cross-examination by my learned friend. Firstly, we don't see what the relevance of this cross-examination is. Secondly, the witness said yesterday that the interview on the 17th was not a warning statement, and if one looks at what the exercise that my learned friend is busy with, this regards a warning statement, unless if my learned friend intends on canvassing a warning statement of accused accused number 2 with the witness. But if one looks at paragraph 1, it states clearly there that this form is applicable in the case of a warning statement, and that in that case the station commander must consult with the prosecutor. So whatever follows, my lord, is subject to the obtaining of a warning statement and not an interview that the witness has testified about.
Yes, ma'am.
Thank you, my lord. My lord, I think I've clarified this yesterday, my lord.
Not clarify it again because Mr. Balo is now objecting.
Yes.
You remember my comments yesterday?
Yes, my lord.
Yes.
My lord, I am not referring the witness to this paragraph because I'm saying that this document was signed or completed by any of the accused.
Fine. What is that document?
It is a warning statement, my lord. And
Okay, fine. Accordingly,
it's the instructions that are given, yes.
when one wants to take a warning statement,
For the police officer to record when he's interviewing the suspect, my lord.
is it for an interview or for the taking of a warning statement?
It is for an interview, my lord. That's why I read paragraph 2, because it says the
fine.
member, paragraph B, my lord. It says,
Let's start from the beginning. What is that document for? Because Mr. Baloyi says it precedes the taking of a warning statement, and you are saying it's for an interview.
my lord, if I can just repeat myself, my lord, yesterday the witness testified that they were interviewing the suspect in the
Fine.
courtroom.
Yes, yes.
Then my question was, my lord, was it recorded? Then I said, where was it recorded? Then I went back to this form to say, this form says the member who conducts the interview with the suspect has to complete this statement fully in the presence of the suspect. And
Okay.
paragraph A, my lord, says, irrespective of whether the suspect has been arrested or not. In other words, my lord, whenever there is an interview between the police and the suspect, that interview has to be recorded because there are allegations, there are constitutional rights that are explained by the police officers at that time.
Fine. And this form, what is it for? The very form. Is it for an interview?
It's for the statement regarding interview with suspect. It's written clearly on the instructions, my lord. In statement regarding interview with the suspect.
Yes, Mr. Baloyi.
And as a court, please, my lord, this is where, with the greatest of respect, we submit that my learned friend misses the point.
Why don't you bring, okay, you know what?
Yes.
Just bring me the law.
Yes.
Okay, because you're
Yeah.
at different
Yes.
poles.
Yes,
Can you
but-
give me the authority you're relying on?
Yes.
And please, Ms. Mshololo, give me the authority you're relying on.
Yes, but-
Can you adjourn for that?
Yes, but can we just make this one point before we adjourn, my lord? Just this one point. If one looks at paragraph A, it says clearly, the station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement.
So the prosecutor must also be involved.
Yes, and this is the emphasis must fall on warning statement. The station commander must consult with the prosecutor in circumstances in which the prosecutor requires that a warning statement of the
taken.
suspect be obtained. And secondly, it says in every such case, in other words, in every such case where a warning statement is required. It doesn't refer to any interview with the suspect. And my learned friend is now opines that in every instance, when a police officer conducts an interview with the suspects, then this process must be followed. It's only in the case of a warning statement.
And that, as I understand the law, that precedes the charging
Yes.
of the suspect.
In-
Okay, can you get me the law so that we don't argue in a vacuum?
As the court
How long do you want me to adjourn?
my lord, maybe 30 minutes because I've already have the authorities. I'll just make the copies.
Do you have any authorities for yourself?
we still have to look up, but it shouldn't take that long.
Okay, 45 minutes.
person is a suspect and has been warned of his rights, and in particular his rights to remain silent before any such interview may take place. Paragraph 31, it serves no purpose to attempt to recognize that an arrestee is not obliged to say anything, make any admissions, or answer any questions unless he is specifically forewarned of these rights and signs in the warning statement that he has been so forewarned prior to any interview or interrogation taking place. My Lord, I will skip all these paragraphs and then just go to paragraph 33. Oh, sorry, my Lord, I have not finished. Yeah, I'll skip this. And then paragraph 34, my Lord, the next page, on page 24, which says, it was startling to hear that both defendants' witnesses, who were experienced policemen, believed that they were entitled to question a suspect or arrestee at any time that they wish to do so without being compelled to complete a warning statement. And the last reference, my Lord, is just one paragraph before it goes to, I'll summarize it, my Lord, paragraph 38.2. Paragraph 38.2, I'll be quick, my Lord, wherein it refers to the warning statement which is headed, statement regarding interview with suspect.
Paragraph what now?
Paragraph 38.2, my Lord. 38.2.
Yeah.
Yes, my Lord. It says, the warning statement which is headed, statement regarding interview with suspect. It is referred to as SAP S3M document and embodies 12 pages on the cover and on every first page under the insignia of the South African Police statement. The statement regarding interview with the suspect. This form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on the portfolio and attach the portfolio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of oaths. Thereafter, my Lord, on the same paragraph, the interviewing police officer is required to record that he has informed the suspect of the allegations, that he is investigating against him, her or her, to ensure that he understands the allegations. There are numerous introductory paragraphs and forms that require completion. The suspect is entitled to make, or if he wishes to do so, whereafter both suspects and the member of the SAPS are required to sign the document. All of the constitutional safeguards provided for in respect of arrest, accused, and detained person are contained herein, and the document sets out each and every step that must be followed in completion thereof. Paragraph, this is the second last paragraph I'm referring this court to, my Lord. There is no basis in law on paragraph 19, my Lord. Paragraph 39. Yes, paragraph 39. There is no basis in law of fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful. I am fortified in my view that the arrest and subsequent detention of the plaintiff in this matter was not, this is for the judgment of this case, my Lord. But can I just read it to complete the paragraph? The matter was not only unconstitutional but unlawfully because the defendant's witnesses testified under oath that they were of the view that they were entitled to interview and interrogate the plaintiff without having completed such a document. This can never be the case. The express term of the document make it abundantly clear that when a suspect signs them, he or she does so in order to acknowledge that he has been notified of his or her rights and he understands them. paragraph 40, the practice whereby these documents are completed merely satisfies the prosecutor that the suspect may now be taken to court is to be frowned upon and not condoned by this court.
And it's a single judge. It's a single judge who says that.
Yeah.
How it is?
Yes, ma'am. It seems that notice in terms of the Constitution is completed before the person is accepted into the cells, but merely as formality and for no other purpose. The warning statement is also completed merely as a formality that is required for administrative purposes or as part of the paperwork, but not for the intended purposes. As previously stated, mere lip service is paid to the rights embodied in the Constitution as detailed in the documents. They are significant in determining whether an arrest or subsequent detention are lawful or not, can never be overemphasized. My submission, my lord, to this court is that this form, it does not, my lord, necessarily say it must be completed when the suspect is charged. But this form says, as I've read it into the record, it must be completed whenever there is an interview between
Who must complete it?
It must be completed by the person interviewing the suspect.
By the police person?
By the police person, yes, my lord. Interviewing the suspect. If I can go further, it even says the number of the people who were present during the interview should also be recorded. My lord.
Have you read Preller's remarks?
No, my lord, those are my submissions.
Yeah, fine. No. I want you to
Yes.
listen to what Preller said, because you brought this judgment.
Yes, my lord.
This was a 3-bench judgment. Preller was the senior judge, Manamela acting, and Kumalo was the other judge. But this is what Preller said. Manamela was the scribe, and the 2 judges overruled him. I have had the benefit of the judgment of my learned brother, but reluctantly find myself unable to agree with the conclusion to which he has come. The evidence was comprehensively dealt with in the judgment of the court of co, and there is no need to repeat it here. Suffice it to say that there were no misdirections in the judgment, and nor did counsel argue to the contrary. The main problem in this appeal arose from the remarks perhaps inadvertently made by the court of co in its judgment on the admissibility of certain crimes as to his co-accused. It is therefore clear that the court was well aware of the constitutional rights of the 5 accused and the discretionary nature of the exclusionary rule contained in section 35(5) of the Constitution. The subsection reads, evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. The prohibition is against the admission of evidence obtained by a process that violates the constitutional rights of the accused. That means only that if the accused person has, for example, been tortured or assaulted in order to force information from him, that information must be excluded. No finding to that effect was made in the judgment. The rule does not mean that any improper conduct, even if unconnected to the making of the statement, results in the exclusion of the evidence. That would be an application of the controversial rigid exclusionary rule of the North American law. I think it's State versus Ross, that case. The trial court is the primary trier of fact, and this court can only interfere with the finding if we are satisfied that it is wrong. A vague suspicion that all was not kosher and is not enough. Unfortunately, we don't know how exactly what the learned judge had in mind with this remark, but the fact is that he considered every detail of the relevant evidence very carefully and came to the conclusion that the evidence should be admitted. In the process, he explicitly rejected the contentions of the appellants that they had been tortured, as well as their evidence that they had made the statement and done the pointing out under it. Somebody interfered with it. Where's the 4th page here? Somebody removed it. Is that page 4? Can I have page 4? Thank you. Yeah. And then paragraph 92 reads, it's page 4. One of the main contentions still read page 19. Paragraph 88, sorry. He says, it is not necessary to set out the evidence adduced in the court below, as Manamela AJ has done in some detail in his judgment. My view and position in the matter is informed by the approach advocated by the court in Take and Safe Trading CC versus Standard Bank of South Africa 2004-1 or South Africa SA 597 SCA 2004, where it was stated, a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side, and the judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. Every person is ensured a right to fair treatment as a suspect and a fair trial as an accused by the Constitution. Section 35 commands that arrest processes and criminal trials be conducted in accordance with the basic principles of justice and fairness. To guarantee the protection, subsection 5 thereof makes provision for the exclusion of evidence that has been procured in a manner that violates any right of the Bill of Rights, if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. To ensure a fair trial, a presiding officer or judge may therefore only consider evidence obtained legitimately to establish whether or not an accused is guilty. However, in terms of subsection 5, if the admission of the evidence would not render the trial unfair or detrimental to the administration of justice, even though it might have been in a manner obtained in a manner that violates a Bill of Rights, it will not necessarily be excluded. Therefore, not every violation of a right protected by the Bill of Rights leads to exclusion. See in this regard, as versus Ndlovu and others, 2002, SCA 70 2002 2 SACR 325 SCA. The section does not couple the discretion to exclude directly to the violation of a right as argued on behalf of the applicant, but to the consequential unfair trial. Therefore, the jurisdictional prerequisites for the exercise of the discretion to exclude is a requirement of unfairness or the prejudice to the administration of justice. What the subsection accords are fundamental and absolute is the right to a fair trial. In S versus Tandwa, 207 SCA 34 RSC8, Cameron 116 observed the pre-constitutional approach to the exclusion of improperly obtained evidence to be in these terms. The noble feature of the constitutional specific exclusionary provision is that it does not provide for automatic exclusion of unconstitutionally obtained evidence. Evidence must be excluded only if A, it renders the trial unfair, B, otherwise detrimental to the administration of justice. This entails that admitting the impugned evidence could damage the administration of justice that could leave the fairness of the trial intact, but where admitting the evidence renders the trial itself unfair, the administration of justice is always damaged. Differently put, evidence must be excluded in all cases where the admission is detrimental to the administration of justice, excluding the subset of cases where it renders the trial unfair. The provision plainly envisages cases where evidence should be excluded for broad public policy reasons beyond fairness and individual fairness and of the accused. Kachalia in S versus Mtombo said the following: public policy in this context is concerned not only to ensure that the guilty are held accountable, it also is concerned with the propriety of the conduct of investigating and prosecutorial agencies in securing evidence against criminal suspects. It involves considering the nature of the violation and the impact that evidence obtained as a result thereof will have, not only on a particular case, but also on the integrity of the administration of justice in the long term. Public policy, therefore, sets itself firmly against admitting evidence obtained in deliberate or flagrant violation of the Constitution. If, on the other hand, the conduct of the police is reasonable and justifiable, the evidence is less likely to be excluded, even if obtained through an infringement of the Constitution. This accords with what Krickler said in the case of K versus Attorney General of the Transvaal, 1996 Constitutional Court case, where it says sometimes even unconstitutionally obtained evidence, because of the demands of public policy and the demands of fairness in the administration of justice, may be admitted, even if you're aware of the case.
Yes, ma'am.
So this case of Hodis, it's not the be it and the be all.
That's the court cases.
I've quoted you two constitutional cases
That's the
where they say even unconstitutionally obtained evidence. Do you have that? Hello? Key, Attorney General of the Transvaal. Let's read it so that everybody knows it. Right? Do you have it?
Yeah, I'm just finding it quickly, my lord.
Yeah, just find it. Yeah, you've got Mr. Computer. So the case has to delve into the intricacies of public policy, the fairness, etc. And this, according to me, this form has got no force of law. Do you agree with it?
As the court cases.
Right, there's no force of law. It's a guideline. But I'm not stopping you from arguing. You can argue that. I'm just saying preliminary. Where's that case?
Oh, my learned friend is finding it.
No, man, just find it. Because people, when they read the Constitution, they all say if the evidence is unconstitutionally acquired, therefore it is not admissible. You further go and examine the phenomena and the exigency under which that evidence has been acquired, the demands of public policy, the demands of fairness, the tension between the demands of the police to maintain law and order and the perceptions of the public regarding the application of fairness. After that, we can conclude whatever cross-examination you
may
want.
other counsels be given opportunity to make submissions?
Yes,
for the
yes,
ruling?
no, everybody,
Thank you, ma'am.
everybody. So Hodes has got a point, but the point is, as I understand the evidence of this witness, predicated on that interview, amongst other interviews, he repaired to Carltonville to go and further investigate. That's what he says, not me. When he got to Carltonville, Ginida came and they went to see the personnel manager, and the personnel manager made a statement to them
My Lord, can other counsels respond at this
Yeah.
stage
No, we're
before
going to
the
read this.
ruling is made?
We're going to read this, and then everybody is entitled to
Thank you.
respond.
As the court pleases.
Sorry, Rose. Let's go and fetch that case. 1996, Attorney General of the. Just, I'll check it out. Do you have it in your computer? Yeah, P. This is KEY. This is Attorney General of the Transvaal, 1996 Constitutional Court. Kirchhoff. You got it? That one. Yeah, that's the one. Sorry. You are Yeah, I forgot class. Baloi, my registrar found the law.
Yes, it's paragraph 23 of the judgment.
Paragraph 23.
It says at times fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Yeah. Go on.
Well, and it says if the evidence to which applicant objects is tendered in criminal proceedings against him, he will be entitled at that stage to raise objections to its admissibility. It will then be for the trial judge to decide whether the circumstances are such that fairness requires the evidence to be excluded. It follows that the applicant is not entitled to an order from this court in these proceedings, that the evidence secured as a result of the searches and seizures will be inadmissible in criminal proceedings against him. I don't think the...
Yeah, read that tension. Why critical reasons like that?
Oh, okay.
Because some of us may not know it. It talks about the tension.
There's paragraph 13. Says in any democratic criminal justice system,
Yes,
there is a tension between, on the one hand,
that's it.
the public interest in bringing criminals to book,
Right?
and on the other hand, the equally great public interest in ensuring that justice is manifestly done to all, even though suspected of conduct which would put them beyond the pale. To be sure, a prominent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by the state agencies in the prevention, investigation or prosecution of crime. But none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical niceties
Stratagems.
and ingenious legal stratagems. What the Constitution demands is that the accused be given a fair trial. Ultimately, as it was held in Ferreira versus Levine, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take that decision. At times, fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Okay, yes, Mr. Mnisi. Mr. Gomezon, sorry. Any submissions?
Court, please. My Lord, my submission, firstly, I would agree with the principle that each case is decided on its own merits. under the circumstances of this exercise or this discussion is that when we look at the interview that was conducted or was held in the boardroom, it was held under a different pretext from the officer. He was booked out from the police cells to the boardroom under a very wrong case, case 163 of 10/2018. When an interview is carried in terms of a docket that is the accused is now facing on the charges of a case docket under 636. My Lord, the unfair part of the principle in the doctrine of fairness lies on the aspect that if a right was explained to the accused, it was in respect of case number 163 and changing tune when they are in the boardroom. So now the accused is no longer, as per the evidence of there's no evidence before this honorable court that accused was interviewed in terms of the Onongoma case. But all that we know before this honorable court is that an interview was conducted relating to the whereabouts of accused number 2 on the date of the 26th of October 2014. Is that fair for the accused in the course of administering justice to be taken by surprise to say, this is what we arrested you for, but now we are subjected now to these particular allegations. Please provide us. To what extent did the rights were explained, especially under case number 636? Second fold of my submission is that it's based on the evidence that is before this honorable court that at all material times when the accused number 2 is booked in and out, there's no indication, there's no entry that he was subjected to an investigation under case number 636. So that would tantamount to unfairness, and that will jeopardize to proper functioning of justice system. In this regard, as the facts are as matters are decided on their own merits, it is my humble submission that accused number 2, they should have actually gave him a clinch or an information. He's the one that he received an information earlier that he is involved in the murder case of Senzo Meyiwa. But when he is booked out, when the rights are read in terms of Exhibit LL, they are read under a very wrong case number.
Okay, thanks.
That's my submission.
Yes, Mr. Nisi?
As it is the court, may.
Yes.
As it is the court, Madam. Madam, I think there's a bit of a confliction.
Conflation.
A conflation of issues.
Yeah, mention them.
Yes, Madam. When this issue was raised by my colleague Advocate Mshololo, and indicated that there is authority, or in fact, each time the suspect is being interviewed, that interview needs to be recorded. Then my colleague for the state stood up and said, but that's not always the case. Then the court also got in and said, as far as the court understands the process, is that a warning statement is only supposed to be filled in as and when the suspect is being charged for him to be prepared for court. My colleague further insisted that, but that is actually not exactly the case. That is when this commotion or this argument actually started. In order to satisfy himself, then the court invited all parties to bring authority before court to support their submission in respect of what they believe in. The defense, my colleague, Advocate Mshololo, brought a judgment that specifically addresses the issue that the court said, bring judgment, bring an authority to convince me. We were expecting the state as well to bring a judgment that will go contrary to what the judgment that has been brought by my colleague is saying. The state hasn't.
Okay.
Instead, what is happening now, my lord, we are trying to confuse two issues that are very distinct. Whether or not it is in the interest of justice that evidence that is sometimes unconstitutionally obtained should be obtained or what. But this is not the crux of the investigation as to why we actually had to come here. In the judgment of Hodes SC, it's very clear. The statements regarding with the interview with the suspect, it's very clear. Each time there's an interview with the suspect, whether or not that suspect is arrested, this document must be filled in with no exceptions. I won't go back and refer to what my colleague has said.
Yeah, I've heard you.
But now, there's also a referral to the case of, to what the Honorable Judge Prela said. These two cases are totally distinguishable because in the Prela case, my lord, it was not about whether or not each time that a suspect has been interviewed, this document 3M in brackets, small letter m, must be filled in. It was only a determination on whether or not the statements that were used in the decision of this case should be used against the accused person in this case or what. So these two cases are totally distinguishable. As I am standing here, madam, I am still expecting the state to present to the court an authority that says no, it's still fine for a suspect to be interviewed without having to fill this SAP 3M in bracket M. The state is not
Okay,
forwarding such information. So basically, we are not saying, my lord, that the court should make a decision here and now.
I'm not going to make, I'm not confused. I'm not going to make a decision now. You're arguing the law. I'm going to make a decision at the end of the case. Don't go about saying, hey, the judge
That is what
I'm listening to the principle of the law. And the decision which I will make will be predicated in the sense that I gave all of you a chance for the input of the very issue which is being debated in this case. But I'm not making a finding, I'm not making a ruling, never.
Yes, my lord, that is basically would have been my next point.
That I'm going to make a ruling.
And no, I intend to say, my lord, that when my colleague, Advocate Mshololo, raised the issue of the interview with the suspect in the boardroom and whether or not this form was filled, it should be something that should be, my colleague should actually be allowed to proceed with that form of cross-examination. It will then only after all the evidence at the end of it all has been heard.
I said
then
that,
the court
ask your colleague, I said that to her. Didn't I say that to you, Ma'am Sholol? That I'm not stopping you from going ahead with the strategy of the cross-examination you are course on. Didn't I say that?
My lord, the problem is that when
all I said, do you admit that this form doesn't have statutory application? That's all. And you said no. But I never said to you, stop your cross-examination. Never. I will never say that to any counsel.
My lord, after I've been granted that leave, my lord, the state objected.
No, but I decide whether you continue or not Mr. Baloyi. Okay.
The state objected, then the court said we must make submissions. Yeah. That's where we're in, my lord.
Yeah, fine.
Thank you.
Yes, Mr. Numalo. Oh, are you still on?
Yes.
No, I just wanted to wrap up, my lord.
Oh, I see, okay.
Therefore, my lord, it will be very precarious. Actually, it will be a precarious procedure to, at this point, decide this thing as if it is final.
Who's going to decide it? I told you I'm going to decide at the end of the case.
The reason why I'm saying this, my lord, It's because I hear already there are authorities that are being referred to which do not specifically deal pertinently with the issue that the court has raised.
Yeah, in other words, you and Mr. Mshololo and Mamalo and Mr. Mugumezuru, Baloi, at the end of the case, they're still going to have to argue
As it please the court, madam.
about the admissibility of these statements and confessions and pointing out Hamadot.
And more particularly with regard to that interview
Yes.
that was held in the
That's
boardroom,
it. You're still
where
going to
this form
argue.
was not fit. Thank you, my lord.
At this
That would be my
stage-
submission.
I had two contrasting legal submissions.
Yes,
That's all.
thank you, madam.
All right. Yes, Mr. Namaru. Hey, my daughter.
Why you be shy, son?
And I may just add, other judges just keep quiet. They keep quiet and then yes sir, yes sir, yes sir, and thereafter they come with a decision.
As it please-
I don't do that.
As it please the court. Yes, that's
I don't do that.
Court should not only be a passive umpire.
Yes,
as it
yes.
please the court.
Yes, Mr. Mumal.
My lord, my starting point will be that it is not enough for the police to use the SAP 14A, because we've been hearing that the SAP 14A was used, that is before and after the accused, that is accused number 2, was at the boardroom.
That's a guideline.
Yeah, as a guideline. I'll re-emphasize and follow the decision of Holtz SC to the effect that whenever the interview is conducted with the suspect, it must be recorded, and the statement regarding interview with suspect form must be used. I'm having the understanding, my lord, that if that is not followed, then it violates the accused rights in terms of Section 35 of the Constitution, and therefore, in terms of Section 35(5) of the Constitution, it stipulates that evidence obtained in violation of the accused rights must be excluded if that or the admission of that evidence will render the administration of justice into disrepute. This form gives an obligation. It's an obligation to the police to say whenever the interview is conducted with suspect, this form must be used.
Yeah, I agree with you. You see, it's incumbent upon you as advocates of this court to make representations to the Minister of Justice to pass regulations
Yes,
addressing the very exigence.
yes.
Manje antet niyakhuluma nje.
It looks like there will be a number of representations.
Yes, you have a right
In this
as
case.
that's how the law develops.
Yes, yes.
When there's a lacuna in the law, the persons who practice in this court they must take it upon themselves to address that lacuna so that the Minister of Justice, Lamula, must address that. Because it's going to recur. That's why you have 9 provinces and you get 9 different decisions in all the 9 provinces. Okay.
Thank you, madam. Thank you.
Mr. Sholo, you are continuing.
No.
You are continuing with your cross-examination.
No, my lord, we're still waiting for this.
No, you are continuing with your cross-examination. Is that not so?
Yes.
Yeah, now we listen to Ubaloi. Remember I said I'm not deciding the issue now. I'm going to listen and hear all of you, what you say. So Baloi must say whatever he wants to say. Thereafter you continue with your
Yes,
cross-examination.
As the
Okay.
court business, my lord.
Is it so difficult, madam?
As the court business, my lord.
Yeah. Yes, Mr. Baloi.
Mr. Court, please, my lord, we just want to come from a slightly different angle, and we raise an objection based on purely issue of evidence, of relevance. You know, my lord, we objected on the basis that the questioning is not relevant in the sense that my learned friend was pursuing a line of questioning that says the accused number 2 made a statement. From the evidence that has been given by the witness, I'm not even sure if one can put it as high as that to say that the accused made a statement. What we have before court, my lord, is
He made a denial.
Yes, it's evidenced by Sergeant Mohani that says we convened in the boardroom with the accused. I warned him according to his rights, and as a suspect, I informed him what the purpose of the interview was, and the accused gave an explanation. I don't know if one can say that it's a statement. He gives an explanation. He says he doesn't even tell him about the date on which the offense was committed. He says, I'm investigating the case of the death of Mr. Senzo Meyiwa. And the accused then, out of his own volition, says, well, I know about that matter. I read about it in the newspaper. Is that a statement? We submit with the greatest of respect, my lord, that if one looks at the form that my learned friend wishes to use to cross-examine this witness, it refers to some sort of a formal statement. All that Sergeant Mukhan was doing was to offer the accused number 2 the opportunity of an explanation, and he says, I was at work, and that defense is pursued. Suppose, my lord, for one moment, that if the explanation that the accused gave that he was at work, if the cloaking records confirmed his version, that would have been the end of the matter. There would have been no need to pursue the matter any further. It could have never been the intention, and even with the judgment that my learned friend has referred to, that where an accused gives an explanation, that the formal process that my learned friend wants to embark upon, that should be followed. These are just preliminary issues that are aimed at establishing whether a formal statement or a statement should be obtained from the accused at a later stage, and which happened in this case, my lord. After these preliminary processes, a formal statement was obtained, to which the investigating officer will refer to when he testifies. It can never be in the intention of the judgment by then Judge Holders to say that in every instance where there's that preliminary inquiry, that this formal process should be embarked upon, that a form should be completed, and the form speaks for itself. It talks about a warning statement. It talks about the involvement of the prosecutor, the station commissioner. We submit with the greatest respect is it envisage a process where a formal statement is intended to be taken from an accused. And if one looks at a discussion under this topic, it all results under section 217, which deals with the confession. So we submit, my lord, that the intention here with this form and with the process that my learned friends wants to embark upon is if, or in the case where a statement of some sort has been made. We also want to refer to the judge's rules, my lord. We know that they have, as it were, been taken over or subsumed by the Constitution, but these rules still serve as a guide.
What is that, 1946?
Yes.
1940,
and 1931.
41, when
Yes,
I was on the queue to be born.
They were approved at the conference in Cape Town in 1931.
Yeah.
And the writer Himstra describes the purpose as follows. He says, these rules are administrative directives for the guidance of the police force. And he says, the judge's rules are mainly of historical interest because they are longer in effect, their role having to a large extent been taken over by the norms in the Constitution. the following is important. They nevertheless remain general guidelines for the police and the courts for the everyday conduct of police officers in respect of suspects. And in this instance, we want to refer to Rule 5, which says, where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is contained in Section 35, which distinguishes between an arrested person and a detained person. And Section 35 states that the person in detention and custody should be informed of the right to remain silent, to be informed promptly of the right to remain silent, and of the consequences of not remaining silent, and not to be compelled to make any confession or admission that could be used in evidence against that person. So if one looks, once again, my lord, this buttresses the point that we are of the view that in this instance, one cannot really say that the accused made a statement, because if one looks at subparagraph C, says not to be compelled to make any confession or admission that could be used as evidence against that person. And the same is reiterated in Section 35(2) pertaining to a detained person. And in this instance, the detained person also includes a suspect who's in custody, as it was held in the Sibajan case. But to come back to the judge's rule, rule number 8 says the caution to be administered to a person, in other words, that he's got a right to not to make a statement, and what the consequences thereof is or are, says the caution to be administered to a person in custody should be to the following effect. And the rules distinguish between a person who's formally charged and a person who's not formally charged. In the case where a person is formally charged, it says, do you wish to say anything in answer to the charge? You are not obliged to do so, but whatever you say will be taken down in writing and may be used in evidence. And we submit, my lord, that this is what this form caters for. And paragraph B says, where a prisoner volunteers a statement otherwise than on a formal charge. In other words, in this instance that we're busy with, if the accused volunteered a statement, and here the judge's rule refers to a statement, where a prisoner volunteers a statement otherwise than on a formal charge, the warning that should be administered should be to the following effect. Before you say anything, I must tell you that you are not obliged to do so, but whatever you say will be taken down in writing and may be given in evidence. We submit, my lord, that what we are currently seized with it's not a statement, it's just a mere explanation, an alibi that the accused gave that he was at work on the particular day, which was subsequently followed. And we submit, therefore, my lord, that this form that my learned friend wishes to make use of is irrelevant, purely on the basis of evidence, and should not be used.
Yes, thanks. Yes, Msholola, you can continue.
Should I
But I
continue?
see-
Yes.
I see the witnesses.
Oh, okay. You want to talk to Mr. Baloyi?
No, le kgopela go addressa kgoro pele Mamsholo la bolela.
I was asking
Le ka
to-
o itshwenya.
I was asking to address the court before the defense asked a question. There is something that is bothering me, my lord.
Okay.
Lekabole.
Maabane kgoro e kgopetše gore ke tle le pampiri ya di-case be re dira maabane.
Yes.
Yesterday, the court asked me to bring a document of cases that we were doing.
So, into this, case now.
I brought the documents as the court has asked me.
Is it now okay?
I've written down all the cases that we were doing and the names of the accused. I also gave it to Advocate Baloyi contained in an envelope. As we were sitting and during the break, my lord, I saw the document. When I handed it over to Mr. Baloyi, it was written confidential. However, I saw the document now roaming around in court, my lord.
Who else had that document?
I saw Muzi in possession of it and all the accused were reading it.
Who gave them that? Do you know? Lieutenant? Wait, let him have his say. Who gave it to?
I do not know who gave it to them, my lord. And now I am being worried, my lord, for our witnesses, especially in those cases. And some of those cases also affect some of the accused. I would not mention them by names. And in all these cases, my lord, there are firearms that are involved. People were shot. People were kidnapped. And other people were threatened. So I was worried if my witnesses would still be alive tomorrow. As I am saying that, my lord, there are a couple of case numbers there.
And computing system computer system SAPS
It is possible that they can go into our SAPS computers so that they would get the names and the addresses of our witnesses. So saying I am not accusing Advocate Mngomezulu, but he brought a certain case which he got into our system of a Nongoma case. And it shows accused number 1.
And more than Sergeant
on top, it shows that a person that has retrieved that case is Sergeant Mngomezulu. I'm not sure if is that sergeant related to him or not. So thus I am afraid, my lord, that will others not be able to retrieve the same information as he received it as well.
manje sengiyazibuza ukuthi laba abanye ngeke bakwazi yini ukukhipha-ke lo ntwazi ngale ndlela naye alikhiphe ngayo.
Bekubala botjha gore na nabo ke tla le pampiri e be ile ya baemedi or e be ile ya baswari bana.
And I would also like to ask, when I brought that document, was it for the defense or was it for the accused?
Manje ngiyabuza ukuthi njengoba bengilethele le maphepha la abe abamaloya noma abeqondisiwe kubasonga yini?
It was for the court. Actually, I'm shocked. I'm shocked. Because that document is supposed to be perused by me first. Because I'm aware of the Intelligence Act, that certain documents are classified. I'm aware of that. I've dealt with cases like this in the past. Even when apartheid was applicable, where you approach a judge in chambers, and the judge makes an order and reads it in chambers to the presiding advocates. But because we are so-called in a new dispensation of transparency, I made it in open court. But that document, or those documents, are not supposed to be seen by anybody except me, first. Are you with me? No. I was trying to avoid a situation where in South Africa people and judges are accused of being bought, being captured and all that nonsense. And I was going to familiarize myself with that information, having regards to the Intelligence Act and protocols. And I would have decided what information, having regard to the proceedings here, has to be divulged to the counsels here. Are you with me, sir?
That is understood.
Mr. Baloyi, what is your excuse?
There's a good case, my lord. The document was disclosed to my colleagues in line with what the court said yesterday, that it's only meant for the eyes of the court as well as the defense counsel.
No, but they said the accused were reading it.
Yes, well,
they got it obviously from the...
yes.
Actually, I'm shocked, that senior counsels like this can actually behave in this matter. I'm just shocked. I explicitly said it's only for the court officials. Now you're telling me the accused are having... This gentleman is right when he says he doesn't know whether tomorrow some of the witnesses will be dead or not. Because this is, unfortunately, is a type of case we're dealing with, unfortunately, where people are said to be shot, etc., etc., etc.
But I've just asked my learned friend to give back the copies to minimize the impact that there might be. And the copies will then be...
Mr. Gumezulu, what's your view now?
My lord, I would like to exonerate myself from...
Hello?
I would like to exonerate myself. I've never consulted with the clients or with the accused.
Where did your clients get the document? Already?
No.
Which client and which accused?
Muzi le kamera one ba khobakanetse mara ba ilebeletse ka mo. Ba le ba sere pampiri jo ka mo.
Muzi and all of them, they were...
Who is Muzi? Accused number who?
Muzi
is number 1.
Accused number 1, my lord.
He was reading that document.
He
took it and he went towards them and they were all together reading the document.
Yeah. And Mr. Lisi?
My lord, I feel a bit uncomfortable when the court says, and I'm saying this with utter respect for the court, when the court says the court is shocked that senior counsel such as us here,
If it's true,
we do such
you're
a
right,
despicable
maybe I made a mistake.
It is indeed despicable.
if it is true,
Yes. But what worries me is, I don't think the statement that has been uttered by the court in the circumstances where it has not been determined exactly what the circumstances were through which this accused person were able to see that document, it's a bit appropriate, because now it seems as if all of us here just decided to stand up and give these documents to
no, fine. You can tell me.
Coming to the accused.
Did your client see that document? Because
I did not consult with my client this morning.
did he see? You don't know if he saw the document.
I don't know whether
Okay,
he saw
fine.
the document
Mr.
or what.
Nimalo?
My lord, I'm not too sure. Why is this witness worried about the statement that he has made? Because in his own statement that he made on the 25th of October 2023, he refers to one of the cases where
Now that's obfuscation. Do you know that word? Obfuscation. Hello? Do you know obfuscation?
I'll have to go to the dictionary.
OBFUSFUCATION. Obfuscation. That's what you're doing. You're dealing with a situation. You're telling me about an affidavit of a person who you say.
No,
We're talking about a court order which said he must bring that information and it mustn't be made available to any other persons except myself, maybe, and
Then-
the counsel. Now you're talking about.
Yes. Then in that information that he provided, in his statement, I'm saying in his statement, he refers to one of the cases that are detailed in that document that he provided to my colleague this morning. One of the cases are referred there in his own statement that he made. So I'm failing to understand, my lord, how I have
You
not...
don't even know what cases he's referring to in the document which he wrote. Maybe the very case you are quoting is not of any moment, according to him. Are you with me? It's like the Nongoma case. You can mention it because we have dealt with it.
My lord, the court is not understanding what I'm
I
saying.
understand fully, sir. So did your client have access to that document, sir?
I did.
This court. Hello?
I did consult with my client.
And you
based
showed him
on-
the document.
I consulted him based on one case that is mentioned in that
Sir,
document.
did your client have access to the document which I said the sergeant should write for my own perusal?
Yes, he did, because I had to consult with my client based on the case that the witness has documented in his own affidavit. The consultation was based on that.
Ms. Bishololo, what's your view?
My lord, may I ask beg leave to consult with my client, because I personally have not read that information.
We are not aware of that information.
But may I just clarify from my client if he...
Yeah.
Thank you. Thank you, my lord, for the indulgence. My lord, I have not read or consulted with my client regarding the document that was given to us by the state. And my client informs me that when they were grouped together with accused number 2, 4, and 5, they were reading this document, my lord. Or maybe if I can just show it to
It's
my
not the
lord.
one that is prepared by.
It's not the one, my lord, yes. And they are indicating the page that they were looking for. Where
Whose
it
document is that?
It's an indictment, my lord.
Oh, they read the charge sheet.
They were reading the charges.
Which they've been reading in the past 5 years.
No, my lord, but that's what
No,
was
I
happening.
hear you.
Yes, yes. This
Where's that confidential document, Mr.?
The document
Because
they
now
were
we're
reading?
getting
Yes.
the fact that now.
Sorry, my lord, can I just get further instructions, my lord? I see the hand is up from my client.
Yeah.
Thank you. My lord, just to add, my lord, as to what were they discussing in this indictment, my lord. He says they were discussing about witness number 104, who is being referred.
Now they can discuss their indictment. No problem. There's
Yes,
no problem.
I just wanted to be clear
fine, I appreciate
as to
that.
what is it that they were
Yeah.
discussing in
This
this.
inquiry is about whether or not this order which I made has been exposed.
Yes. Those are my submissions.
Mr. Baloyi, where's that document which you given by?
I'm just trying to get all the copies from my colleagues.
My lord, before the copies are being taken back, with due respect, my lord.
I want the copies which the gentleman, the witness, made to be put in the same envelope which was supposed to be for my eyes first. You know, during apartheid, I must say this, we had apartheid judges in these treason trial cases where a judge would make an order that an investigating officer should do what I did. And then he would say that the order is just for the court. And even the counsels who were in court would never ever be aware of that order, because the judge then had a discretion whether to disclose that information or not. And invariably he never disclosed that information. Now we think we've got a democracy here which is functioning. And then court officials will know what to respect when a judge says that order is made to divulge certain information which is not supposed to be made available to the public. Just check whether all these documents are the ones which you... Do you have a copy of the original document?
No, ke di file Ntate Baloyi, ke mfile
How many?
file Ntate Baloyi original document.
I gave Mr. Baloyi the original document
And I did a copy.
and he made copies for himself.
So there was one document.
The document here did.
So na ke na yona, ke tla nkirele yona.
Okay.
I do not have it. I said he should do it for me.
Is it Gininda who will know, just listen to me, is it Brigadier Gininda who will know under which section of the Intelligence Secrets Act these documents are categorized?
Le go tlo kgonagala gore le tsebe gore ditokomane tše di mo sectioneng e feng.
Ke tseba ka di rinda le mo secret service le crime intelligence.
I am informed that they are on the Secret Service and Crime Intelligence.
Okay, can you bring those documents?
Sure.
In the nature of things, these documents are not going to form part of these proceedings because that evidence has now been contaminated. And this court has got a discretion to decide whether to make these documents available as I originally intended. Because from what this witness is telling me, if I do that, some people's lives will be jeopardized. It's not saying that. He talks about people being killed. He talks about guns swirling around. He talks about kidnapping. He talks about whether his witnesses will be safe and alive tomorrow. So this court makes a ruling that this information has been expunged from the record of these proceedings on the basis of the fact that it may jeopardize other persons' lives, which are more important than the life of this judge. Okay, Ms. Michelle, let's go on.
My Lord, can I ask that we take the long adjournment and I'll resume after lunch?
Okay. What's the time there?
I think it's 2 minutes after 1. My Lord, we're debating the issue. Is Counsel now going to proceed?
Yeah, I'm going to proceed with the cross-examination.
Along the lines that she was doing.
Yes. But the only order I make is that this confidential information
Khoro e re ditokomane tsela tse le ba fileng tsona ga di jwale khoro e tlilo di swara ka lebaka la mabaka a besitseng le fane ka ona e be go bolelwa ka maphelo a batho.
Bonke bakhethelekile ukuthi usetshenziswe walethela enkantolo kuyazochithwa enkantolo ayasasetshenziswa kulolu daba.
just for my own edification, where are the dockets?
Di docket di kae?
Docket ya Fosloras. Since ba isha decision I so
Case number?
Di case number e feng?
534.
Aksa go pola case number.
What's the charge? What's the charge?
Yeah.
Molato wa bona be le
Personal dealing in drugs.
dealing in drugs, my lord.
Yeah, it's 534 if I recall. 534
Something, yeah.
of 6.
Khoro e re e ka re ke 5346.
And the other one?
Yengwe.
Ekia Nongoma 163 of 10
And this one it's for Nongoma 160
of 10 2018.
of 10
160
2018.
of 10, 2018.
Yes.
Where is the docket?
E ka yo.
Normally ishila ke ikere my lord because Kenel Ginda we will some rota tla lebella.
I
Okay.
did not get it where I left it, as Colonel Ginda said he will come and look for it.
And the other one?
Yengwe guy.
No chona chepe make.
Those are the two that the court needed.
Okay, 2 o'clock.
My Lord, can I make one submission, my Lord, with due respect? I know the court has ruled, but it is my request that that information that has been taken back from us, it must not also be kept with the court,
Why not?
because that information is coming from the witness.
Did you hear the ruling I made?
Yes, my Lord.
What was the ruling?
That we are not entitled to it. The order was that the witness must bring this information for the court purposes.
Right.
Yes, my Lord. My request, my Lord, is that the information cannot come from the witness direct to the court without us having been given an opportunity to look at the information that is submitted before this honorable.
I thought you had seen it, all of you. You just gave a copy. Didn't you give a copy?
I have not seen it, my Lord.
Okay, take
I have
it.
not seen it, my Lord. Thank you.
This information will form part of the proceedings of this. Just give it.
As the court
So that
visits, my
if
Lord.
this case goes somewhere else, the
Yes.
judges in the SCA
SCA.
and the judges in the Constitutional Court
Thank
will
you.
have access to this.
As the court visits.
I'm not so naive as to take the information which has been led to this court and go and keep it in my sitting room.
Thank you, my Lord.
Judge over kgopela gore ditokomane tsela di ska ya thuso go kgoro then wa disco.
Hi. Now they're trying to that order must be expunged. But after having consulted authorities, in terms of our law, there's what we call a posterior ruling, a statement. And Black's Law Dictionary, the 10th edition, defines it as such. A formal statement endorsed on the trial record. That's what I'm doing. I'm endorsing this order, which I thought it's going to be confidential, on the trial record. Giving an accurate account of the proceedings at the trial, which I hope are done. A record of what occurred at Nisi Prius after the issue had been joined. The issue was joined on the basis that when this witness, Sergeant Mohanene,
Yes, my lord.
was being cross-examined, he repeatedly said he's unable to divulge the information regarding the investigations of the cases which you say accused number 1 or 2 or the others they're involved in, because you would be revealing confidential information. Am I quoting you correctly?
Ke nnete gore kgoro e re lena le rile go na le dilo tse e leng gore ga le kgone go di bolela ka lebaka la gore go na le ba bangwe ba ba latofatšwa ba e leng gore ba gona go melato e nngwe gape le tlabe le ntšha dilo tse e leng gore di diphiri ka sewe sebaka.
Ke nnete.
It is correctly quoted, my lord.
Yeah, because this court hopes to be fair. There was a dispute as to whether this witness is actually, his testimony is actually the truth or not. And at that stage, this court is not involved in joining whether this witness is being truthful or not, because he's at the moment giving evidence. This court decided, in the interest of justice, that if it is actually correct that these cold cases he alludes to, including the Nongoma case regarding the murder, the court should make a request in the form of an order that this witness should itemize and categorize those cases in which he says they are cold and they are at the moment not yet finalized, because it was put to him that, for instance, that Nongoma case was finalized, and he said no, it's not finalized. And by that exigency, this court expected and hoped that this court will get the information which it will share with the accused counsels, that in fact, indeed, such cases are still being investigated. Is that not your evidence, sir?
Ga se botlhatse ba lena se kgoro e fetsa go se bolela ka dijalo gore di melato e nngwe e sa ntse e nyakišiša.
Ke nnete.
It is correct, my lord.
Consequently, that's why I made that order. And I was of the view that that order is made for the information of this court. And in terms of this posterior principle in our law, I was going to call all the counsels into my chambers and show them the confidential information which was divulged after being extracted by this witness from the various dockets. Because I believe that counsels are officers of this court before they are defenders of their accused. That's a sacrosanct principle of our law. You are officers of this court before you are defenders of the accused, because when you are admitted as counsels of this court, you take an oath to uphold the law practices of this court. So one would have expected that even if counsel informs their clients about the fact that in fact it is correct that there is proof that some of the cases which the gentleman is giving evidence on, saying they are cold but they have been resuscitated, in fact it is correct that those cases are being attended to. And I believe protocol dictates that not everything which this court divulges by intruding into the Official Secrets Act. And if counsels understand that exigence, you don't have to tell your client about the fact that they say one of the murderers there is Mohache, because you are enjoined to the privity of the information which has been divulged in this court, because this court has made an order that even if it is in terms of the Official Secrets Act that this witness was saying he can't divulge that information, but this court, using its inherent jurisdiction and Section 173 of the Constitution, as Mr. Minister likes saying, you can make use of that information under certain conditions. Okay. So consequently, if anybody wants to use that information, which has been so irregularly been divulged, you are at liberty to do so. And this principle starts from the 15th century. So that you mustn't say, I did judge there is a long church. With the verdict of the jury in the 15th and 16th centuries, the proceedings at Nice was closed, and the case was sent back to the court at Westminster, from which it was issued for judgment after a statement of the holding of the trial and the verdict that had been added to the record, as I'm doing. This statement, from the fact that it has begun with the Latin word postea, or afterwards, was known as the postea and was in fact drafted by the party in whose favor the verdict had gone. Whence the phrase postea to the plaintiff or the defendant, which is found in the old reports. You can see in this regard Geoffrey Ratcliffe and Geoffrey Cross, Legal Systems, England. It's a 6th edition textbook written by Bentley and Hand. It's the 6th edition if you want to read about this any further, 1977. Okay. Yes, okay, Miss Msholove, you can go ahead and cross-examine.
As the court visits, my lord, before I resume with my cross-examination, can I just ask one thing on clarity, my lord? So it means that on this document, I can read it but not consult, share it with...
No, it has already been shared. You can read it and share it with your clients. That's why I insisted that each of your clients should be given that document, so that it mustn't be said that this information which this court has withheld.
That's the court. Thank you, my lord.
Yeah, well.
Sergeant Mohane, let's just go back where we paused yesterday. I'll try not to repeat myself, but we'll just wrap up somewhere there and there where I need clarity on those issues.
Mara ba tlo tswela pele mo ile gore le shile gona maobane ge ile gore bona ga ba nyake le gore ba boele go tšeding tšadilo e fela ge ile gore bona ba tlhoka gore ba kwešiše dilo tše di rileng ba tlole buša ka tsone le a kwešiše. That is understood.
Lesubela emuva kuloko esikhule esikhuma ngizona hasiqeda konke kodwa khona izinto ezifanele zicacise.
For the sake of progress, you remember we were talking about the interview that took place at the boardroom.
Gore re tswela pele jwate le a gopola gore be re bolela ka polekšano ye diragetseng ka boardroom. Yes.
I'll just ask one question in that regard and then move on in that aspect.
Ba tla botšiša potšo e tere ka yona tabewe ye be le gore bona ba tswelela pele. I am listening.
The interview that took place between yourself and other members and the suspect was not recorded.
Interview yela ye leng gore lena le be le gona le ba bangwe ba be leng gore le be le tshana le bona be se e recordilwe ga se gatišiwe felo tsoko. Correct.
Okay. If I can just take you back, also I just need confirmation. When you firstly approached accused number 2, when you arrested him, you explained to him the allegations in respect of the Nongoma case. Am I correct?
Ge le ya go molatofatšo wa bobedi la mathomo le ile lena la mpotša ka molato la wa Nongoma. Correct.
Okay. And then when you were charging him,
ge be le mo rwesa melato
then which allegations did you refer to him?
le mmoditše ka gore lena le morosha molato ka eng.
Abantu basekele izomthethicala belitshela ukuthi umthethicala ngaliphi.
ele ka tlhalosa le bolela ka e sale ka June.
Can you please explain further? Are you referring to the month of June?
Yeah, the month of June, you have arrested him from his house. And then you explain the allegations in respect of Nongoma case. Correct?
It is correct.
Yes. And then you took him to the station.
La Misha's police.
Nnete.
That is correct.
Wherein he was charged and detained.
Ke mo ba ileng ba morosha melato la moswara.
Nnete.
That is correct.
Yes, at that time when you charged and detained him, which allegations did you explain to him? Was it in respect of Nongoma case or in respect of this case, Phosphorus case 636?
Rene le motswallele le be le mmoditse ka melato e mefeng, le mmoditse ka wola wa Nongoma go ba le be le mmoditse ka wo wa Phosphorus.
Re monitse ka molato wa Nongoma.
We informed him about the Nongoma case.
Okay. So, then on the following day when you booked him out, you then interrogated him on the Phosphorus case 636 and not Nongoma case.
Letšatši le latelang re be le montšha le yo mmotšiša dipotšišo le ile la mo thoma dipotšišo ka molato wola wa Nongoma e seng wa Phosphorus.
Re thomile pele ka Nongoma then ra latela ka Phosphorus.
We firstly interrogated him on the Nongoma case and then followed up with the Phosphorus case.
And then in respect of this Phosphorus case 636, the accused number 2 denied any involvement in this case. Am I correct?
Molatofatšo wa bobedi ka molato wa Phosphorus 636 yena o ile a ganela gore ga se nke ya ba karolo ya molato o ke nnete. It is correct.
And then, in respect of the Nongoma case, if I remember very well, your response yesterday, he was never taken to court for his first appearance at all.
Ka molatola wa Nongoma ge ba go gola botlhatsi ba lena ba maobane lena le rile ga se nke a ishiwa kgorong.
Hello botsa botse we re mishitse kgorong go me re fitla kgorong mtšutšisa reno ka gore bjale Nongoma e a se re tšutšiseng ya gare and then la ba re mmisha ka ya Phosphorus.
If you would recall properly, we took him to court and the prosecutor said this Nongoma case, it's not under their jurisdiction, and that's when we had taken him for the Phosphorus case.
Yeah. Yes, but in essence, he was never taken to Nongoma court for his first appearance or for his appearance under that case. After the prosecutor has said that he does not have jurisdiction over Nongoma case.
Kamraga gore motšhutšisi a re yena yela ya Nongoma ga e ka fase ga jurisdiction ya gage ke mo e leng gore yena a se nke a tswelele pele ga kgorotsheko ye e rileng ka molatola wa Nongoma. It is correct.
Okay. So it means, Sergeant Mohane, on the 19th, I suppose we are on the same page that you saw the prosecutor on the 19th of June.
Le dumela gore le bone motšhutšisi ka di 19 tša June. That is correct.
So it means on the 19th of June, when the accused was not taken for his first appearance, the 48-hour rule expired in respect of Nongoma case, since he was never taken to Nongoma Court for his appearance in that case.
Gora gore jwalo ka ga lena le bone motšhotšhisi ka di 19 ke ge e le gore ge molatofatšwa ba sare yena a tsena ka kgorotshekelo ke mo e leng gore di-houra tšela tše masomenne seswai be se tše di expirile ka molatong ola wa Nongoma.
Manje njengoba yena ngamisanga enkantolo mayelana necala kaNongoma usho ukuthi ke la mahora amashumi amane nesishiyagalombili usho ukuthi ayeseqile mayelana necala kaNongoma.
No, we saw expired.
No, the 48 hours had not yet expired.
It's fine, I'll leave it for argument. Let's continue. You then, on the same day, on the 19th, when accused was not taken to Nongoma Court for his appearance, in Fort Loras, his case was not enrolled, and he was supposed to be released. Am I correct?
Jwalo ka ga lena le re ka di 19 tšhekong yela ya Nongoma ga se a ye go dula go yona go ra gore yela ya Phosphorus o be swanetše molato ola wa gagwe o tšhollwe go jwalo.
That
is correct.
Ngoba ke azange ngene icala lendaba kaNongoma usho ukuthi ke icala sePhosphorus lalifanele lichithwe ngaphandle ebese yakhululwa umsolwa athi kunjani.
And he was not released. Am I correct? According to the exhibits that we have read into this court.
Go ya ka botlhatsi bo lena le bo badileng mo kgotla tshekelo ma lena ga senke le moloko le molatofatso.
Kodwa zange nimkhulule njengokungala maphepha phambi
And a further detention after there was an endorsement that the accused must be released was unlawful because you did not have any warrant of arrest to arrest the accused on any other further or subsequent cases that you were investigating.
Se se bolelang gore lena le tswele pele le moswere besitše go le ka ntle ga molao ka lebaka la gore le be le sena tokomane ye be le dumella gore lena le be le ka moswara goba le ka motswallela nako e nngwe e fetang eo. It was not unlawful, however, we did not have a J50.
Thank you for
avalele umsolwa usho ungasekho emthethweni ngoba nani nazo incwadi zokuthi ningamvalela ngalama yebo kodwa ke sesingaya J50.
Yes, at that time when you did not have a J50 authorizing you to detain accused number 2 further after his matter had not been enrolled in Fort Loras, you took him further for further investigation. Am I correct?
Gora gore jwalo ka ga lebele sena yona J50 yela lena molatofatšwa le ile la motšea le ge ile gore lebele sena tokelo ya gore lena le ka moswarella lena la motšea le ilo mmotšiša dipotšišo le ilo nyakišiša. It is correct.
Njengoba nani ngenayo J50 kodwa na vele namthatha umsolwa naqhubeka ukwenza uphenyo athi yebo.
Okay. And am I correct to say after Fort Loras Court, when he was detained around 1339, you recall me if I'm quoting the time wrong, it was 1339. From 1339 up to the time when he was detained at Pukeng police station, you had no warrant of arrest in your possession to keep the accused in your possession.
Ora gore lena go tlogelle nako yela ba re le tla ba phosholla ge le gore nako ga se ba e be ga botse nako yela ya 1339 fihlella le be le ilo mo tswallela ka kwa ka police station ya Phuket ra gore lena le be le sena tutukelo tša gore le be le ka moswara.
La película sona isikhathi ka-1339 ikofika isikhathi nambadla ngaso ekhulwini ngenalo igwelo ukuthi ngaba nembambeli wathi yena.
Okay. If I also recall your examination in chief, the reason for you to take accused number 2 to his house is because you wanted to check the hoodie that he was wearing.
When the
incident in the Fort Loras case 636 took place.
Mo be leng gore molato wa Fort Loras case 636 o be o diragetse ona.
a ke le kwešiše le ka boeletša gape ke le ko e botse.
I do not understand. Can you please rephrase so that I will be able to understand correctly?
Okay, thank you. I'll repeat. And if I'm correct from what you said, your evidence before this court, you said the main reason you did not release the accused from Counsel court and proceeded to his house because it was because you wanted to go and search for the hoodie which was worn by the suspect on the date when the incident took place under case 4/636, which we are dealing with in this matter.
Le rile lebaka le le dirileng gore lena le ska tala molokolla ke ka lebaka la gore lena le be le nyaka go misha ntlong mo be a dula gona gore le ilo lebella hudi go ba ke ga yela ye leng gore ba bere ka judge le be go diragala molato wa phosphorus case 636 yer bolelang ka yona ya mo
Kushuthi sizathu sokuthi ningamekhululi emva kwase phosphorus ukuthi nanifuna ukuya endlini yakhe ukuthi niyohlola ukuthi ningayithola yini le hoodie yayigqokwe umsola kuleli cala lase phosphorus 636 kunjani?
Ka ge re sa kgobeketša bohlatse bja 636 ke nnete.
Yes, as we were still gathering evidence for the case 636, he is correct.
Okay.
Yebo kunjalo ngoba ngesikhathi sasazamhlanganisa ufakazi ukungasiza kuleli cala lika 636.
Is it also your evidence that in 6 years' time, from 2014, 15, 16, 17, 18, 19, 20, 6 years later, you proceeded to accuse number 2's house with an intention to search and seize when you did not have a warrant, a search warrant in your possession in respect of the case or in respect of the information that you wanted to search and seize?
Ke nnete gore lena mo mengwageng e etsela le bentse le nyaka go ilo tswella pele le ilo lebella le ilo tlhola kwa gagabo goba mo be a dula gona le ge e le gore lena le be le sena dipampiri tse e leng gore di be di dumella gore le kae le ilo searcha.
Emva kweminyaka eyisithupha nasuka nemzini kaMsowesibili ukuthi niyohlola noma niwenza uphenyo noma ukuyosesha ningenayo iwarrant mayelana nalezi ukuthi niyozithola lapha kuyani.
Ge le ka gopola botse molato a so thome ke rena mathomo for 2014.
If you would remember properly, this matter, we are not the first investigators since 2014.
Ngakhumbula kahle thina ukuqala ukuthi siphenye lolu cala kusukela ngo-2014.
O fitile matsogong a mantši kudu o fitlhela rena ba re fa ona.
There are many investigating officers that has worked on this case until it was brought to our attention.
Baningi abaphenye leli cala lapho izolethwa kwe-ET.
Rena re hweditše molato ka December 2019.
We got this matter in December 2019.
Thina sathola leli cala ngo-December 2019.
Okay. Thank you for that explanation. But I don't have a problem with how many members who have investigated this case. That's not my question. That's not where I'm going to. Whether you were the 15th or the 30th member to investigate this case. But on the 19th of June, when you went to search in accused number 2's house, you were not in possession. You did not have a search warrant authorizing you to go and search the item that was worn by accused 6 years back. That's my question.
Ake ba leboga le gore le nna ba botse gore ga se nna ba mathomo ba go bereka go molato eupia selo se ba se bolelang ba re ka di 19 kgodingela ya botshela le nna le be le sena ditokomane tse leng gore di be di dumella gore le ka sepela le ilo nyakishisha ka mola ntlong ntho e leng gore molatofatša o be a ya pere mengwaga ye tshela ye fitileng
Kuzothi kusho ngishana nje kuJune. Manje ayiphethe iwarrant yokuthi niyosesha lapha endlini kaMsola ufuna lezi ekuthiwa zazigqoke Msola ile minyaka eyisithupha eyadlula.
Go na le molaotsoko ka mogare ga Criminal Procedure Act o re dumelelago go swara ebile le go searcha re sena warrant ebile re a tsa go pola ke tla ile go lebella rena gore molao go.
There is a certain law in the Criminal Procedure Act, even though I would not recall which section refers to that. However, I will go and search for it, which allows us to arrest and search a place even without a warrant of arrest.
Yeah, no,
or a search warrant.
No, thank you for that. Don't worry about that law. We'll argue about it before this court. The only confirmation that I want to get from you is whether did you have a search warrant or not.
Ba re le ska tsunyega ka molato o bue bona ba tla o lebella gape ba tla ba boleshana ka ona gona mogoro. Lena, we did not have a
Thank
search warrant.
That's all I wanted. That's all I wanted. And then you entered accused number 2's house and you searched and recovered the ammunition. Bullets, if I'm not mistaken. Am I correct?
Le ile la tsena ntlong ya molatofatso wa bobedi la tlhola kana ka molala khumana dipule dikolo. It is correct.
It is correct.
And also, you did not have the search warrant regarding any bullet or any firearm that you were looking for.
Le bentse le sna yona tokomane ya gore le search re be le ile khumana tsona dikolo tse. It is correct, so.
Okay. Thank you. Let's go back a little bit on the occurrence book. Since we have testified, maybe you can refer if you want, but I will remind you.
Ba re tlo boela morago go occurrence book ge ile gore le na le nyaka le ka ya go yona fela ba tla le go botsa.
Accused number 2 denied any involvement in respect of Foster's case 636 when you interviewed him in the boardroom on the 17th of June 2020.
Molatofatso wa bobedi yena o ile a gana gore e be ile karolo ya molato wa Phosphorus case 636 ka di 17 ja June 2020.
So the hospital appeal to Yana, I think I already looked at the 66 was supposed to have been cancelled due to the boardroom manning moves and moves.
It is correct.
That was the first and genuine response given by accused number 2 when he was asked about this matter of Foster's case 636.
E be ile karabo ya gage ya mathomo ya nnete ge be le motisha ka molato wa Phosphorus 636.
Kwako upendulo yakhe yokuqala upendulo manje mbuzo ngale 636.
Re ya nnete le ra ya nga re e tshwate go le phetulo ya mathomo ya nnete a kushilo le ya nnete ra ya.
What do you mean when you are saying the first genuine response from him? Because we were expecting the first answer from him.
Let's move on. Let's move on. On the 18th of June, he was then booked out for the whole day on the 18th of June. You remember? At 8:15 as per serial number 520. That's the exhibit entry that you have read into this court.
We at 8:15.
He was booked out at 8:15 and only detained at 2:30 in the morning.
Le motere ka 8:15 yena a bushwa ka 2:30 ile 2:30 ya matsha. I do not have it, however I do remember that.
Okay, June, why can't go 8:15 here? Madam, local 502 was only some 2 XA.
And then on the same day, on the 19th of June, at 2:35, the suspect was charged. You remember?
That
morning.
The 19th of June, ka 2:35 ke mo e leng gore molatofatšwa o ile a rwešwa melato le ya go bona.
So then
Yeah,
I'm trying to
Opole.
give
Yes, I
him,
do recall.
With 2:35 umsola ilapho katsho sicalathi yebo ngikhumbula.
And early in the hours of the same day, 19 June at 4:50, the suspect is booked out to Foster's court.
Le ya go bona gore ka masa ka tsone di 19 ja June ka 4:15 ya masa ke mo e leng gore molatofatšwa wa tšewa o ishiwa kgorotshekelo ya Foster's.
4:15 ngalelo langa umsolo wakhishwa enkundleni yamacala yaseForloras.
Nnete.
It is correct.
Yebo kunjalo.
And according to your examination in chief, when you were on your way after you had booked out accused number 2, you were called by Colonel Gininda, who told you that accused number 2 wanted to make a statement. Am I correct?
Le ya go bona gore lena le rile ge le le mo tseleng ge le gore le ile la khumana mogala go tswa go Colonel Gininda a le botsa gore le molatofatšwa o be a rile o nyaka go bolela ntho e rileng.
Usakhumbula ukuthi ke nathi kusendleleni nathola ukuthi ngivela ku-Colonel Gininda ethi ke umsola ufuna ukuyobhalisa ke i-statement esithize.
That's not the evidence I listened to.
Oh, sorry.
They got a message from Gininda to say, no longer go to
Court.
the court.
Yes.
Go to Morocco because I have now located a person who can take a confession. After Gininda had told them the previous day, told accused number 2, if the evidence of the sergeant is correct, that you don't have to make a confession or a statement before me, I'll find somebody to take your confession. Okay, that's the evidence.
Yes, my lord. Should I
Not
withdraw
that
the-
Gininda told them on the way to say the suspect wants to make a confession. No,
Okay.
we had
But,
already said that the previous day.
my lord, but the call was made in the morning when they were on their way to Foster's court
To say what?
to say that the accused must be taken to make a statement.
Yes.
Yes.
Not that he wants to make a statement. Because the arrangements were already made by Gininda, in other words.
Thank you, my lord. Can,
Yes.
can I just proceed, my lord?
Yes,
with
do proceed.
the line of my questioning, because I'm now getting distracted.
You are not, Ms. Msololo. I'm quoting the correct record, what it says. You can ask Mr. Mgomezulu, am I confusing anything?
No, my lord, this
Hello?
is the correct.
Ms. Msololo was not there. I'm quoting the correct evidence. Now I'm being told I'm distracting.
Thank you, my lord.
Please.
My lord, can I proceed, my lord? My question is, why now, when the accused has been booked out from 8 o'clock up to 2:30, when he was booked back, now that he has changed his mind?
Ba re putso ya bona ba nyaka go tseba gore go banneng jwa tje ge mo
Is it good, please, my lord? I don't know why counsel says the accused has changed his mind. The court is just now put to counsel what the correct version is, that the incident started already the previous day on the 18th when they were in Carltonville, where he intimated that he would want to make a statement, and Brigadier Gininda then said to make arrangements. And on the 19th, he contacted the witness to say he has made arrangements. There's no change of mind.
Can I rephrase that question, my lord? Is it correct that the accused only indicated that he wanted to make the statement during the time when he was booked out for long hours, from 8:15 up to 2:30 in the morning, when he indicated that he wanted to make a statement?
a fa ke nnete gore molatofatšwa yena o rile o nyaka go dira statement nako ela ge ne ba mo tšere nako e telele go tlogeleleng ka 8:15 go fitlhelela ka 2:30 ke mo e leng gore o ile a re o nyaka go dira statement.
Once again, I don't know whether the the part that says when he was booked out for long hours is correct, my lord, because the witness said it was around 4:30. So it was from 8:15 to 4:30 when he signaled his intention, when he made certain admissions, Lord, and arrangements were then made. I think the addition of long hours will not be correct.
Thank you, my lord. I'll leave it for argument, my lord. Can I just move on? Because the hours are indicated from the OB entries, my lord. Let's move on, Sergeant Mohane.
Taba hela ya di-iri tse ditelele ba tla e lesa, ba tla e share-a bona ka bona. Ha ne jwale re tswela pele.
Is it also your evidence that when you were with accused number 2 in hospital or outside hospital, he was also asked about the involvement in the case of Phosphorus case 636?
Ke ba lena na gore molatofatso e rile re be re na le yena ka ntle ga sepetlele.
On the 18th of June, when you booked him out and went to hospital or his place of employment?
Ka di 18 tša June re be le mo putile out le ile sepetlele goba mo be a šoma gona. It is not the hospital, it is where he was working.
Where he was working. Thank you. And where he was working in hospital, you also had interview with the suspects.
Mo be a bereka gona le ile la kgona go boledišana gape le yena le ba le interview. Are you saying before or after we had checked that was he at work or not?
No, at that time. At that time, I don't know according to evidence. It can be before, it can be after, I don't know, but you were at his work employment at that time when you interviewed him.
I was What I remember is that I said Brigadier Gininda joined us with Sergeant Mohola.
Brigadier Gininda where's our Sergeant Mohola?
Yes, and then what happened?
And we were waiting for them at the gate outside the mine.
So what did they somewhere upon the mine?
Brigadier Ginda fitla Sergeant Mohola ka introduce a Brigadier Ginda waki Sandy Sontanzio.
And when Brigadier Gininda came with Sergeant Mohola, I introduced him to the Brigadier that this was Sandy Swa Ntanzi.
What you make Brigadier? No, Sergeant Mohola. I said, me too. Get we are Gedona who Sandy sometimes me too la go Brigadier.
Vela mochara re to verify gore ka nnete go le moshomong na ka ge ke mmodi tša Brigadier.
And Brigadier said we are here to make sure whether were you indeed at work, as I had explained to the Brigadier.
I think I said so good to we better open because of
That is the conversation that we had before we went into the mine.
Okay, in other words, at no stage wherein the accused was asked about his involvement in this case at that time.
Ga gona mo eleng go fatswa o ile a botšišiwa ka kamano ya gagwe go molatong.
Futhi lapho akukho la umsola abuzwa khona ukuthi uthengiteka kanjani kuleli cala.
No, Brigadier General Muchisha, after Amu Murijem Ditokolo Chaga.
Brigadier asked him after he explained his rights to him.
Ubrigadier wamtshela emva kokuthi wambuza emva kokuthi amchazeleke amalungelo akhe.
And were you present?
Lebelele hona. Yes, I was.
Wakhona thi yebo.
Okay. Did accused respond?
Molatofatwa o ile a araba.
So waphendula.
Awila Homola.
He remained silent.
Uvele wathula.
And then on the 19th, early in the morning, when you had received a call that an accused person must be taken to Lieutenant Colonel Rapado, did you take him to any police station
Hoseng
according to your evidence?
re le na le fumana mogala wa gore molatofatwa o tshwanetse a issuwe go Lieutenant Rapado le ile la misha.
Ekuseni yomntana uma senithole uxolo ukuthi nihambise umsolwa ku-Lieutenant Colonel Rapado namhambisa na.
Erimishije Maroka Police Station.
Yes, we took him to Moroka police station.
Yebo samisa eMoroka police station.
Okay. Am I correct, Sergeant Mohane, to say from the appearances as they appear that he was booked in the early in the hours? It means the suspect on that day he did not sleep.
Ora gore bona ba bolela nnete na ge ba re ka mokgo dilo di bonagalang ka gona jwalo ka ga ile gore yena o ile a ngwetswe gore o fitlhitswe mola mogare ga masa ra gore molatofatwa a se a robala.
Ngendlela obonakala ngayo ke uthi wakhishwa ngasikhathi sini bona sengathi umsolwa azange kuthole ithuba lokulala kunjani.
Ke agana ka roba robetse kolong ya rena ntse re tsamaya.
I dispute that as he was sleeping in the vehicle as we were driving.
Hayi ngiyafika la ngoba ayilele emotweni ngesikhathi sihamba naye.
Okay. But he was not put into the police cells where he was allowed to sleep.
Efela ga se a tsentshwe ka diseleng mo a ile madumella gore a robala.
Ukuthi azange afake amaseleni kufanele ulale khona.
That's a good question, what is the basis for counsel to say that the accused was not put in a cell and allowed to sleep?
My Lord, I'm seeking clarity from the witness looking at the time when he was booked out, my Lord, from the cells and the time when he was booked back in the early hours. That's why I'm just getting clarity from the witness. Maybe he was allowed to sleep. That's why I'm just getting clarity from the witness regarding that.
As I understand the evidence, these witnesses, they were from Pukeng, am I correct?
Le lebeletswa Pukeng.
That 18.
Or Chabani, whatever.
Go ba Tlhabane.
Okay.
Lebeletswa kae?
That's our call, okay, fine.
I do not recall.
Okay,
my
yeah,
lord.
continue with your questions.
Thank you, my Lord. You can't answer that. You can't recall, or you remain with your answer to say he slept in the vehicle when you were traveling.
Le santse le yeme mo karabong yela ya lena ya gore o robetse ge bentse le reile.
Ona le mo
Ukuthi walala emotweni ngesikhathi nina.
ona le mo re musheditseng ka mogare a robala ga nyane mara ke tsona robetse nako e kae.
There is a point where we took him back to the cell and he slept a bit, even though I do not recall how long
Khona
did he
isikhathi
sleep.
esambisa naphakathi ukuthi alala wala isikhathi esinana sakhumbula ukuthi wasinana.
Oh, okay. I can refresh your memory because I have recorded the entries. From Pukeng, he was booked out 8:15 in the morning and he was only booked in at 2:30 on the 19th of June.
Ba re batla le go potsa go bana ba dingwe fase go tloga Pukeng.
And then he was
O
charged.
ntshitswe
He
ka
was charged.
8:15 go fitlhelela ka 2:30 ya masa.
Yes.
Sukela ephukeni wakhishwa nga-8:15 wazoyobuyisela ngaphakathi ekuseni ngo-2:30.
And then he was booked out at 4:50 after that entry.
Ba ntshiwa ka 4:50 ka moraga go ngwetswe jwalo. It is correct.
Can you recall anything or you can't recall?
Go na le ntho e le kgonang go e gopola go baka le sa gopola.
Khona lisakhumbula noma awusakhumbuli?
Go gopola gore re mtsentshitse diseleng ya re boa.
I recall that we had placed him in the cells when we came back.
ngiyakhumbula ukuthi samphendisela emaseleni nasesikhulu.
Bile re mo ntshitse ka diseleng gape re tsamaya.
And we took him out of the cells when we left again.
Yes, so
Sakhipha emaseleni ngemasisamba futhi.
if I understand what you are saying, so you would have booked him, you would have put him into the cells after 2:30.
Se se bolelang gore lena le mmušeditše diseleng ka mora ga seripa ka mora ga iri ya bobedi.
And he was
Nami phindisela emaseleni emuva ka 2:30.
and he was taken out at 4:50.
La montšha ka metsotso ye lesome ka pele ga iri ya bohlano.
So selukhipha ngo-4:50 futhi.
That is correct.
Okay, kunjani?
So in other words, it means he was only detained for 2 hours. He was only put into the police cells for 2 hours.
Se se bolelang gore o tsentšhitšwe ka diseleng iri tše pedi fela.
Ke nnete.
Correct. Buyisela emaseleni wahlala nje amahora amabili athi yena.
Okay. And he made the statement.
It's actually not 2 hours. We don't want to be pedantic, but it's more than 2 hours. 2.5 hours minimum to 2:25.
Manus, the witness can correct that. The witness is the one who knows better. If I'm not giving the correct estimate, you know how long was the suspect put into the cells.
Le ka lo magareng la botjeo. 3 hours and 2.5 hours.
The time could be between 2 hours and 3 hours.
Isikhathi esiphakathi namahora amathathu.
From my calculations, from 2:35 to 4:40, it gives me 2 hours 20 minutes.
Go ya ka yena ge a se tša dira di-calculation go tlogelela ka 2:35 go ya go 4:50 e mo nea di-iri tše pedi le metsotso e masome a mabedi.
Okay, so lesi sikhathi siqala sika 2 hours 50. Ukuyofika 4:50. Nika amahora amabili imzuzu sangaba amashumi amahlanu amabili nanhlanu.
We wetile go bolela ke.
You have said it correctly, so.
Thank you. And it is your evidence that when he was taken to make the statement, sorry, my lord, not that can I rephrase? Not that it is your evidence. Am I correct to say that when accused number 2 was taken to Lieutenant Colonel Ropadu, he had not slept, he had only been kept in the police cells for 2 hours 20 minutes.
Ke nnete gore molatofatšo wa ge be a išwa go lephodisa Raphato yena ga se a robale o loketšwe fela ka diseleng iri tše pedi le metsotswana.
Ngabe ikhuluma iqiniso yini uma ngithi-ke umsolwa isikhathi angena ngaso emaseleni nokuthi athathwe kayiswe esikhishwe siyiswa ku-Lieutenant Raphato wayiswa nje wayehlala nje imizuzu amahora amabili nemizuzu.
Nka se ra robala ka ge ba isha diseleng ba ishwa ke maphodisa mo police station yo.
I cannot say he did not sleep because when they are taken to the cells, they are taken by the police officers from that police station.
Ngeke ngisho ukuthi engadanga ngoba uyiswa emaseleni bahanjiswa amaphoyisa lapho kuleso station.
Okay.
Sorry, I don't want to interfere, okay? You see the defense that was put by Mr. Mgomezulu is that this witness, accused number 2, was never taken to Rapat. He was taken somewhere to be assaulted, choked, etc., etc., etc. Inanda comes there, opens the boot of the car, gives him documents, sign here, sign there, sign there. Assaulted again, then they realize, oh, something has not been signed. Then they take him to Morocco now. And when they get there, are you with me?
Yes, my lord.
These versions, I want to be fair to you, Mr. Mgomezulu, and you, they are mutually destructive. Because the way you are putting it, it appears as if you are not disputing the evidence of this witness. When in fact, according to Mr. Mgomezulu, he never ever took Mr. Tinzi to Rapat. He met somewhere in the hospital, etc., etc. Keys were given, blah, blah, blah. Taken to an open space, assaulted. I'm just saying it.
Thank you, my lord. I was just referring the witness as to how the incident
No, no, fine.
unfolded during the time when he was booked out up to the time when he
Yes.
was booked back
Yes.
in the early hours.
Okay, no problem.
Yes. I have not touched the issue of the accused and the Lieutenant Colonel Rapado. I'm just talking about the night preceding to that
It's fine.
incident, my lord. And I did not get the answer.
It's a Karawayal Nabi.
Kana le rileng hapa ka re sa
By the
ba
way, what was-
ka o sheletsa ka
What
ka
was your
kgopela.
question as you have distracted me? May you please repeat the question?
No, I had said it means for the whole night the accused had not slept. If he had slept, he only slept for 2 hours that he was put in the cells.
Bona ba rile go ra gore bosigo ka moka mola tfatšwa ga se a robale ge ile gore o robetse yena go ra gore o robetse di iri tse pedi fela
Futhi angisho ukuthi umsola akazange alale kulobo busuku. Uma ukuthiwa kwazi ukulala amahora amabili kuphela.
Ga robetsa ra go robetsa na go ka ya mi ya di 2 hours and 40 minutes 20 minutes.
he slept, meaning he slept that 2 hours and 20 minutes that you have referred to.
Okay.
Wayalala ulala yona nama-hours ukhuluma ngawo amabili.
And then on the 22nd of June 2020, when the accused was taken to court, he was taken not for Nongoma case. Am I correct?
Go ra gore ka di 22 tša June molatofatšwa ge se a išiwa kgotlatshekelo yena o ba sa išetšwe molatola wa Nongo.
Which he was
Mhla
detained.
22 kuJune umsola umeseyiswa enkantolo wangayiselwa leli cala kaNongo.
O be a tswaleletswe wona.
Lelo ayeboshelwe lona.
La o shetswe for poking.
He was taken for cocaine.
For okay.
Ayiselwa icala lasePhukeni.
Okay. And from the evidence of Jonathan, Mr. Buthelezi, and Mr. Buthelezi, they testified that they were asked by yourself on respective dates when accused number 1 was taken to make a statement to Lieutenant Rapado, and when accused number 1 was taken to make a statement to the magistrate, Ms. Cronje. Their evidence is that they were requested by yourself to escort you as you were traveling.
Jonathan Buthelezi.
I'm sorry, accused 2, not accused number 1.
Jonathan Buthelezi bona ba boletse botlhatsi ba gore ba be ba boditswe ke lena gore ba sepele le lena ge be a ilo dira statement sela go magistrata e leng gore molatofatšwa wa bobedi e leng Mdanzi o be a ilo dira confession ye we goba statement seo.
Kusho ukuthi ukwazi okuvela kuJonathan novela kuThelezi ukuthi umsola wayeswa kulaphathi isa statement futhi wayeswa futhi magistrate ukuthi ayobhalisa statement nokuthi ke nina wena wabacela ukuthi bazoniphelezela.
E re ke tlhalo tšetše kgoro ka tsela e.
May I explain it to the court in this way?
Angikaze ngalendlela phambi kukaTona.
Ekurhuleni Metro Police Department e kgopetšwe ke Brigadier Gininda le di supervisor tša Ekurhuleni mo Metro Police Department gore thuša re go sepediša di suspect tša rena ka yona molato.
The Ekurhuleni Metro Police Department was requested by Colonel Gininda and the supervisors to accompany us as we were traveling with the suspects in this matter.
Abasendleleni ke bacelwa uGininda wakhuluma nezikhulu zasekhululeni ukuthi kuzophelezelwa ke lamasonto.
Okay, in other words, you are saying you were never involved in the request that was made requesting the members to give escort to yourselves.
Ka mantswe a mangwe lena le re ga senke le be karolo ya kgopelo yewe ya gore le kgopele gore batho ba utlwe ba tlo sepela le lena.
Kusho ukuthi wena awungenasandla isicelo lesi sokucela ukuthi niphelezele.
Ka ge šetše ba ba file tumelo ya go šomišana le rena.
as they had already given them the right to work with us.
Njengoba sebegunyaziwe-ke ukuthi bazosebenzisana nathi.
Well, ba re fa tumelo la gore rena re bereka mo fase mo re kana ra founelana ke gona le mshomo tshwantse re o dire.
And they gave us the right to contact each other if there was any duties that we were supposed to do as we were working on the ground.
Thina-ke la abaphansi-ke sasisibeka ukuthi singathintana uma kukhona umsebenzi owadinga ukuthi sisebenzisane kuwo.
Okay, so as you had been given a right to communicate, were you given specific members to request from the metro each and every time when you needed their services?
Ba ile ba lefa batho tsoko gore lena ga ile gore le tlhoka tshumishano le bolele le batho ba rile.
Manje ukuthi naniwe ikithole ukuthi ningasho ukuthi obani ukusebenzisana nabo basenkundleni uma ukuthi khona umsebenzi ofanele wenziwe.
Ke nnete ba re file yona group eo.
Correct, we were given that particular group.
Iqiniso sanikwa bona-ke labo bantu.
In respect of accused number 1, in Albertine on the 30th of May, were you also present?
Albertine ka kwa ka di 30 tša May go ya le molatofatšwa wa mathomo.
Nana nomsolo wokuqala kuhleka 30 kuMeyi. Nani seliwe yini ukuthi nihambe nalomsolo ni-Albertine?
On the 4th of June. On the 4th of June.
Ba re ka di 4 tša June.
Actually the 5th of June.
Ke nnete.
Yes, it is correct.
Who arrived first at the Albertine station between yourself and Jonathan and his crew?
Go fitlile mang pele magareng ga lena le Jonathan le setlhopha sa gagwe ba sepodising sa Albertine.
A ke sa gopola botse re fitlhela mampela a ke sa gopola botse mara bona ba fitlhile re rena fitlhile.
I do not recall who arrived first. However, they arrived and we also arrived.
Okay. Do you recall as to where were they waiting, Jonathan and his team?
Le sa gopola gore Jonathan le setlhopha sa gagwe ba eme kae?
Ya gopola.
Yes, I do recall.
When?
Yakhumbula yini ukuthi uJonathan nethimba lakhe babemephi?
Ka ntle ka police station.
Outside the police station.
Babeme ngaphandle police station.
Thank you, my Lord Medical. Just bear with me. Thank you, my Lord. I've got no further questions.
Okay. Yes, Mr. Oh, you said you were waiting. Mr. Baloyi, any re-examination?
You were asked by counsel for accused number 1 and 2 regarding the appearances of the accused in Boksburg.
Botsitswe ke ramolao wa molatofatšo wa mathomo le wa bobedi ka go tswelela fua Boksburg.
This is now as far as Exhibit E is
Umsolwa
concerned.
wokuqala nowesibili mayelana nokuvela enkantolo yaseBoksburg kaMsolwa wesibili.
Ba re go ya ka botlhatsi bola ba E, did you say exhibit E
Yes,
or
Exhibit EE
EE?
Mamela ne-exhibit EE
on the 27th of October
Ka di 27 ja October
27 October
2020
ngwageng wa 2020.
unyaka kwawo-2020.
as to whether you had permission from the station commissioner to postpone to postpone accused number 2 to the area police cells.
Gore lena le be le filwe tokelo ke station commander gore le ka molatofatswa wa bobedi yena le ka moisha diseleng tša Deleria.
Okuzwa ukuthi ke nanayo imvume yokuyisa umsolwa emaseleni aseValeria ngokuya kwemvume nayithola ngokuya ka-station commander.
Indeed.
That is correct.
Yebo kunjalo.
Yesterday, we handed the original of exhibit EE
Maobane re fane ka tokomane yela ya EE.
Zolo-ke khona-ke i-exhibition esikhuluma iyona.
Bakgopela lwadi.
I just want to draw your attention to a letter my lord, the letter would appear right almost in the middle of the proceedings. If we can just place the contents of the letter on record.
Ba re ba nyaka gore le ye go lengwalo leuwe le lebale le godimo le kgone go kwagala.
Yela ukuthi ngifundele encwadi ngifundele enkantolo.
Language gore the station commander South African Police Service Valeria
Bale ukuthi station commander wesiteshi saseValeria
magodimo nothi inquiries Colonel Toga
bale lapha ngenza ukuthi inquiries.
On top it's written inquiries Colonel Toka,
gomme ba i-addressitse the magistrate senior public prosecutor Boksburg Magistrate Court Boksburg
and it was addressed to the magistrate senior public prosecutor in Boksburg Magistrate Court.
Eqondiswe kumantshini enkulu yaseBoksburg.
gomme yone ngwala ka etsela permission to place a suspect at Valeria police cells.
And it reads as follows. Permission to place suspect at Valeria police cells.
So ifunde kanjena ukuthi-ke imvume yokufaka umsolwa emaseleni aseValeria.
Here, point number 1 is here with permission to place under mentioned suspect at Valeria SAP cells for further detention.
Point number 1 is read as follows. Here with permission to place under mentioned suspect at Valeria SAPS cells for further detention.
Sokuqala ukuthi isicelo sokufaka umsolwa emaseleni aseValeria.
gomme ka mo mašakaneng e ngwetše case number 436 of 10/2014
And in the box is written case number 4/636/10 of 2014.
Lapho kubhalwe nenombolo yecala 636/10/2014.
gomme lešakana la go latela le ngwetše gore name of a suspect Bongani Ntanzi.
Second block, it's written name of the suspect, Bongani Ntanzi.
Ngokulandelayo kubhalwe igama likamsolwa uBongani Ntanzi.
lešakana la mafelelo e ngwetše Colonel B.N. Gininda.
The last block is written Colonel Investigating Officer, Colonel B.N. Gininda.
Ekugcineni kubhalwe ukuthi umseshi uLieutenant Guinea.
Point ya bobedi ngwetso re permission is granted by Colonel Toka SAPS Valeria.
Second point, its written permission is granted by Colonel Toka, SAPS Valeria.
Ke imvume yanikwa uKolonel Toka wasesitishini saseValeria.
Mo fase assign engwetso station commander Colonel SAPS Valeria MS Toka.
And underneath the sign, it is also written Colonel Station Commander SAPS Valeria, MS Toka.
Enzathi besika sana ukuthi station commander saseValeria uKolonel MS Toka.
Kamo fase angwala date 2020 of 10/27.
Underneath, it's written a date 2020 of 10/27.
Uthe enzathi wasefaka nosuku umhla 27 October 2020.
A copy certify again na PV Mohani, Castampisa clerk of the court of Boxbeck Police Station.
And a copy.
Court, Boxbeck Court.
A copy was certified by myself, Mr. Mkhani, with the stamp of the clerk of the court.
Ngihamba isigqibizo sasenkantolo sokuthi ngathi yiyo ngempela isigqibizo sasetshenziswe sasenkantolo yaseBoxbeck.
That is all.
You were also asked by counsel for accused number 1 and 2 as to how you know Mr. Mjiako.
Lilela botšishwa gape gore Mr. Mjiako yena le motsedi le jwang botšishwa ka ke moeledi wa molatofatso wa mathomo wa bobedi.
Ummeleli kaMsolokane wesibili babuzayo futhi ukuthi mazi kanjani uMjiako.
And you then gave an explanation. Can I once again ask you to turn to the transcribed version of Exhibit EE on the 27th of October?
Balere go mola ye leng gore e typilwe ya 27 October yona ye ya EE.
Manje
La fana ka tlhaloso.
exhibit ile akhombisa khona ukuthi kwakuqoqe phansi.
Yes, I can see.
Who appeared for case number 2?
Ke mang o be e le moeledi wa molatofatso wa bobedi?
Ubani owanele umsolo wesibili?
Ingwetso gore Mr. Ntokozo Mjiako attorneys.
It is written Mr. Ntokozo Mjiako attorneys.
So lapha ke uNtokozo Mjiako owasefemini labameli labaMjiako.
The case was then postponed to the 27th of November, the 2020.
Molato o o ile wa hlekisetswa morago o ishiwa go di 27 tša November 2020 go jwale.
Leli cala ke lasethuselwa umhla 27 November 2020 akunjani?
On the second page.
Mo paging ya latela.
Uthasini elandelayo.
Ke nnete.
It is correct, I confirm.
Iqiniso.
Who appeared for case number 2?
Ke mang o be a emetse molatofatso wa bobedi?
Ubani ke owayemele umsolo wesibili?
Isangwetso Mr. Mjiako gape.
It is still written Mr. Mjiako.
Kusabhalwe yena obaMjiako.
Thank you.
Ba leboga.
Are you through with that letter, Mr.?
There's a formal letter that is on record. If I can just ask you to put the contents thereof on record.
Ba go na le ngwalo shile ba gopela gore le lebale le tle le gona go bala.
Khona ke incwadi ke engifisa ukuthi uyifunde ukuze iqoqwe phansi.
Mo mengwalo nge megolo godimo ga letlakala engwetso Mjiako attorneys incorporation.
In bold, on top it is written Mjiako Attorneys Incorporation.
Ngamagama ke amakhulu ubhale lapha phezulu ukuthi abameli babaMjiako.
Malatala mengwalo ring the Director of Public Prosecutions, attention Advocate Jibaloi, per email la on ngasibali.
Then it is written, the Director of Public Prosecutions, attention, Advocate G. Baloyi, and an email address. And the witness says he would not state the email address. The date,
Dating was 3 March 2021.
it is dated the 3rd of March 2021.
Whenever like I say, like, dear says.
It is written as follows. Dear says,
Ngala kapeka mengale mekutunyana RE/Ntanzi for Soloras case 636 of 10/2014.
also written in bold, RES stroke Ntanzi for Soloras case 636 10 of 2014.
Icala lasephosphorus 636 of 10 of 2014.
Point number 1, we confirm that we act on behalf of Mr. Bongani Sandison Ntanzi, who is accused number 2 in the above matter.
When number 1 is read as follows, as the witness has just read it, my lord.
And then, immediately after the last court appearance, Mr. Ntanzi withdrew a mandate as his attorneys of record and opted to be represented by the Legal Aid Board.
That is the second point, my lord.
We also not been receiving financial instructions from Mr. Ntanzi. Point number 4, Mr. D.N. Mjiyako, who has previously appeared on behalf of Mr. Ntanzi, is no longer with our firm and has joined the Cape Bar as a people advocate. I am mindful of our duty to formally inform the court about these developments and to withdraw as Mr. Ntanzi's attorneys of record. However, due to a family bereavement, I am unable to make it to court on Friday, 5 March 2021, and my colleagues are out of the province. Point number 6, may I therefore humbly request your assistance in informing the court on our behalf about this development and to request that our non-appearance be excused and our withdrawal of attorneys of record be confirmed. Point number 7, thank you in advance for your kind assistance herein. Yours sincerely, Mijaka Attorneys Incorporation, DL Chia.
Thank you. It was put.
No. Put in the practice number. Remember the allegations.
Yes.
Subtle allegations that this gentleman is a fly-by-night counsel or attorney.
Yes, just put the practice number.
So put the
Practice number.
legal practice number.
Mofasi in which legal practice counsel number.
At the bottom it is written legal practice number.
18209.
manje la kufanele inombolo yabo yelogunyaza ukusebenza njengabameli ithi 18209
CIPC reg number
balokuthi CIPC reg number
2017 stroke
2017 stroke
149
149
229
229
stroke 21.
stroke 21.
It's a vet number
And it is also written the VET number.
Kubhalwe i-vet number
451028
451028
4914.
4914.
Barbara Leboga.
Mr. Baloyi, put the address of this attorney on record because I see it here.
Barbara Lekabala, le address.
But we don't know whether he has an office or not. When the evidence was unfolding, it doesn't exist, apparently.
Address ya gagwe ba la ka tsela e
Ikesi la ke lifundeka kanje.
The address is right as follows.
10 8th Street, Melville, Johannesburg.
10 8th Street, Melville, Johannesburg.
Well, phone number.
Should I read the phone number
code?
as well, my lord?
Yeah, the code.
Telephone
Postal
jala
code.
Our code is 2109.
2109.
Telephone number
Cingo
plus 2711
plus 2711
482
482
2325.
2325.
Email address
Email
info@mjiago.com.
info@mjiago.com.
Website
That's your website.
www.mjiago.com.
www.mjiago.com.
Directors, is it necessary?
Yes, it's not necessary, but
Hey, it's necessary. Why do you mean it's necessary?
no, we're just going to refer to the senior
Because
associate
this gentleman practices in partnerships.
as a good.
It's not a sole practitioner.
As a good, we just wanted to put the senior associate on record. Who's the senior associate?
Imam Womogolo.
Obani ababambisene nabo abaphezulu.
He was a senior consulting attorney.
Are you referring to the one that is written?
No, senior associate.
Directors.
Well, we just mentioned the directors.
They-
The directors.
Okay, just
You
put
don't
the
have to
right.
mention the qualifications. That the directors are so and so and so and so and so and so.
Barley Bale, the director.
Senior associates, so and
Abaqondisi
so.
abakhona la.
Director Iridineo Chia, Managing Director,
Batumi abaqondisi Dineo Chia,
LLB Limpopo.
LLB Limpopo.
Katiso Mphahlele, LLB Vets.
Batukatiso Mphahlele wase LLB oyithole vets.
LLM Labor Law UP.
Atwathola LLM yomthetho wezinsibisebenzi oyithole UP.
Certificate in Law Dispute Resolution Stellenbosch.
Atwathola icertificate sokuxazulula sase-Stellenbosch.
Senior Associate in Tokozo Mjiago,
Senior Associate uDawson Mjiago,
LLB Vets,
thole LLB vets.
PDM Vets.
Atwathola EDM nase-vets.
Natalaki Senior Consulting Attorney Melanie Naidu,
Kukhona senior consulting attorney kumelana nayidu.
BA Vets,
Atwathola BA yase-vets.
LLB Vets,
LLB yase-vets.
LLM Vets,
Atwathola LLM yase-vets.
Advancing Diploma in Banking from Bankers Institute of South Africa,
Atwathola certificate zase-banking council yase-South Africa.
Junior Consulting Attorney Faith Huntley,
Atwathola ummeli uBates Huntley.
LLB UNISA.
Thole LLB yase-UNISA.
Ibala ka tsela eo.
Thank you. It was put to you by counsel for case number 2 regarding exhibit RR. There is now the court proceedings in Phuket.
Moleledi wa molafatwa wa bobedi yena o ile a bolela ka botlhatsi ba RR e leng dilo tse di diragetseng kgorong ya Phuket.
And then so our command kwenzeka bese kuyengi lapha kwe-RR.
Inete.
That is correct.
Kunjani?
It was put to you that accused number 2 did not appear in court on the 22nd of June 2020.
Ba ile ba le botsa gore molatofatso wa bobedi yena ga se a tswelle kgorong ka di 22 tša June 2020.
From Mr. vele ka tokhatho 2 2020.
I do recall that.
Ngiyakhumbula lapho.
If I can ask you to turn to exhibit RR.
Ba re le go botlhatsi ba RR.
Vele uyosheka lapha ku-exhibit RR.
Yes, I am in possession of it.
If you turn to the 4th page from the beginning.
Ba re le tsebeng ya bone.
Ungaya ekhasini lesine.
Yes, can you just place on record what's written there?
Ba re le re botse gore le pageng la bone go ngotsweng.
Mashere uthi ekhasini lesine ubhalwe lapha.
P04.
On top it is written P04.
Kubhalwe uthi P04.
A171/20
A171/20
on 13 of 7 2020. On 13/7/2020.
on 13.
No, the 4th page from the beginning.
Ba re le menyala page la bone go tlogelleng mathomo le la mathomo la bobedi la boraro la bone shediwele le bane.
Yes, can you just put that on record?
Ba re le re balle yona ewe.
What's your agenda 29/6/2020?
Kwake kwahlukana can you give me the date again?
29 of 6 2020.
29/6/2020.
Legal aid in custody, no bail.
Bathi-ke wayemele legal aid ungaphakathi akanayo ibhili.
And what is your recollection? Was, as far as the presence of the accused at court on the 22nd of June 2020 is concerned?
Lena kgopolo ya lena e reng ka go tswelela ga molatofatso ka di 29 tša June 2020?
Manje-ke wena khumbulani ngomfika ngomsole enkantolo mhlaka 29 June 2020.
Molatofatso o tsweletse pele ga kgoro ka yona di 29 June o išitše ke nna ka sebele.
The accused appeared in front of court on the 29th of June and I personally took him to court.
No, we're talking about the 22nd of June.
22nd, yeah, 22nd, oh yes.
On the 22nd.
Msolo wavele enkantolo mhla 27 June 2020. What happened is
Right, then on the 29th of June, just the following page, 29 June 2020.
That is 29 June 2020.
manje ngomhla 29 June 2020.
Just place on record what's written there
Re botse
by the
gore go
magistrate.
badileng.
Manje sifundele lapho ukuthi kuthiwani.
Yes, 29 June 2020.
Agenda 29 June 2020, legal aid in custody, no bail.
Kwake kwahlukana mhla 29 June 2020. Umsola ngaphakathi kumele i-legal aid futhi akanayo ibhili.
Yes, then the following appearances on 29 June.
Ye latelang the 29 June.
Here the page 4, the 13th of 7 2020.
No, 29
of June. Wait a second.
It's written page 3 at the top.
Ba re godimo e ngwetswe page 3.
Actually, page 3.
There is no page 3 on this document. This one does not have page 3.
Yes, was the entry there?
Which is page 3, A171/20.
By page 3 number
A171
A171
from 20.
stroke 20.
in which on the 29th of 6, presiding officer Miss A. Rose. Miss A. Rose. Prosecutor Mr. Lestroke, Mr. Mohapais.
No, 29 June is written page 3 after. Yes.
Yes, I'm reading.
Yes, the witness is on 29.
Oh, there, okay. Or Yamatomo in which your court not working.
First one is written court not working.
Acute not brought in court, isolation for COVID-19. Adjourned to the 13th of July 2020 in absentia in custody, no bail.
Do you remember this appearance of the 29th of June 2020?
Yes, I do remember it, my lord.
Do you remember why the accused was not before court on the 29th of June 2020?
A case here, COVID-19, Valeria police station.
Yes, I recall because there was a case of COVID-19 at Valeria police station.
Thank you. Counsel for accused number 1 and 2 also referred to exhibit VV1.
VV1.
It's a report from Tabani. Dental services.
VV1.
Yes, I can see it. It is in front of me.
The date is the 22nd of June 2020.
Date is 22 June 2020. That is correct.
You mentioned in cross-examination by counsel for accused number 1 and 2 that you took accused number 2 for this dental examination after the court appearance on the 22nd of June 2020.
Lile la bolela re be le botšwe ke ramolao wa molaofatšo wa bobedi gore le na lile la mešha ba ile go tlhola meno. It is correct.
What was the purpose of this examination, the dental examination?
Lebaka la gore a ile go tlholwa ka menong e be e le eng?
Re dutse re phenya molato wa 636 wa kry-a le gore mo senepe se ba montšhintše go sona o ba na le gold go tswile motho a rona le gold so be re o tšhakwana sala ba le gold na mo menong.
Whilst we were still investigating the matter of 636, there was a picture which depicted a person that had a gold tooth, my lord, and we went to see if he has ever had a gold tooth before.
Can you just place these details under other details on record?
Ngele bale mola mo go ngwetseng other details le di bale.
The other details with you. Look how too short the more.
Can you please show me where, my lord?
Patient report.
Or patient report?
Patient, okay. Further details.
Further.
Yes.
Patient report have been admitted for a heart condition in 2014.
Umsolo ke wake wathathelwa wahlolwa ngokuthi kwaba nesifo senhliziyo ngo-2014
following mining accident.
emva kokuthi ke kube nengozi yasemayini.
If I can ask you to turn to Exhibit JJ.
Ba kgopela gore le ye go botlhatsi ba JJ. I do not have JJ in my
Copy. There on the ST, can you just put in record what Ms. Cronje wrote there?
ba re le ba botsa gore Miss Cronje o be a ngwetseng.
Tsela o tshele nkolo Miss lapho ebhale.
There where there's a star.
Bathi la kunenkanyezi khona.
I do not want to report any medical conditions or injuries.
Yes.
Athi akukho ukuthi ngibike ngikulimala nokuthi lethe umbiko ngizempilo.
Except had a heart problem.
Manje ukuthi wakwaba nesifo senhliziyo.
Thank you.
Sorry, that annotation by Ms. Cronje, what date was it made?
It was on the 24th of June 2020.
24th of June. Okay.
Exhibit JJ.
2020. Exhibit J.
JJ.
JJ, yeah. That was the pro forma.
The performer.
Okay.
Now, if I can ask you to turn to page 2 of Exhibit VV1, the dental report.
Ba re le go page 2 botlhatsi VV1 e la report ya go tlholwa ga meno.
Passing this
There's a clinical examination.
Go na le mo e leng gore ba mo tlhola bona.
It was put to you by counsel for accused number 1 and 2 that accused number 2 was tortured, assaulted, and chewed on the 19th of June 2020.
Ba ile ba le botsa gore molatofatwa yena o ile torturiwa a betwa gape a ka di-19 tša June.
Ummeli kaMsolo Sibili uthi uMsolo Sibili wothi wahlukunyezwa washaywa wasefakwa neshophu ngomhla ka-19 June 2020.
During the oral examination, what was the finding regarding the general appraisal?
Ge ne a tlholwa a menong bona ba boletse goreng
General
Mehlolwa ke kwabikwa kwathini
general appraisal very normal.
ke konke kulungile.
Yes.
TM joints normal.
Number 10 joints akahle.
Lymph nodes normal.
Ama lymph node alungile.
Intraoral exam normal.
Bheka la ngaphakathi kulungile konke kulungile.
Lips and buccal mucosa normal.
Wathi ke isikhumba phakathi komlomo neindebe zomlomo zikahle.
Oropharynx and tonsils normal.
Wathi ke ama-tonsil nala qoqoqo konke kulungile.
Palate normal.
Ke ngaphakathi emlonyeni ngaphezulu phahla lomlomo lona kulungile.
Floor of mouth normal.
Ke lana ngaphansi emlonyeni konke kukahle.
Tongue abangwala silo.
On tongue, they did not take anything.
Elatela ngiri gingival and periodontium yangwala abnormal marwangwala ginginal recession actually wawali number 41423
And it is written ginginal recession of 41 stroke 42 stroke 3. Yes.
Periodontium going gingival recession of 4142 interdental spacing nakona 112 to 122
megamorphosis yangwala angle classification class 1 and then your teeth chart interdental spaces your 11.12,21 come on class you have 23,12 very true category like so on
And on the teeth chart, it is written class 1 interdental space 11 arrow 12, 21, 22 arrow 23, 12, and it seems like there are letters that were cut, my lord, as the witness cannot see them properly.
lapho ukhombisa-ke ukuhlala kwamazinyo ukhumbela-ke isikhala phakathi namazinyo kuthiwa kunesikhala phakathi kwezinyo 11 lokufika kwelesibili nesikhala esingemva ka-21 bese kuba nesikhala phakathi kwezinyo lemashumi amabili nezinyo lemashumi amathathu kwase kubekwa-ke nesikhala ngaphansi kwezinyo leshumi nambili kodwa khona okunye kungaseceleni okugcineni kungasabonakali kahle.
The God please, my Lord, this is quarter to 4. It's way past our normal time of
We're still going to go on.
Can we adjourn about 1 or 2 further questions? Maybe then adjourn until tomorrow.
Okay, any objections? Adjourning at quarter to 4?
Up to.
There is none.
My Lord, may I make a request on the? I'm not intending to. I'm not intending to interject on the evidence that the state is busy with. I believe the document that the state is busy with was not admitted under Section 220.
Which document is that?
The one for medical examination of the accused.
The one of the dental examination?
That's correct, my Lord.
You told me that you agreed.
No,
You,
I just consulted.
Mr. Baloy, didn't you tell me that?
It was handed up by the defense, my Lord, and we said we don't object.
On one specific.
So you are objecting to its handing in?
My Lord, it related to the date of the 22nd of June.
Yes, but the point
not
is,
on the
are you
contents.
objecting to the admission of that?
That's correct. That's correct, madam.
You are objecting to it?
Yes, correct.
But it's before court me. You can address me tomorrow.
That's correct, madam. I'll do so.
And who handed in this document?
It's the defense, my Lord.
Yeah, as I recall, Mr. Mugabezulu himself. Okay. Can you number that order, that court order. Give it a citation. I don't know exhibit what. Are you with me?
Yes, it will be exhibit W.
Exhibit
WW.
Exhibit WW. That is the apparent confidential report of the sergeant. Are you available tomorrow, sir?
Yeah.
Okay. 10 o'clock tomorrow.